Yes, let me begin with a caveat. The present proceedings fall within a very narrow compass. Already, yes, already there is a direction and everything has been laid down. Whatever the practical difficulties, this one vacuum is to fill up. Only to, yes.
That is a narrow.
That's all because,
further hearing.
yes, yes.
We will simply make it a little bit more workable.
Correct.
We can't be, reviewing it.
Yes, exactly, exactly.
Now, what are your suggestions?
Yes, what I've done is, as per your Lordship's directions, I've taken para 198 and I made a chart. And where is unworkable, we have put it in red. What is the, so there are two things.
So that what is the provision to be substituted, that's all.
Yes, yes. So the changes are
need for any discussion, order and all that.
So what we have done after.
We dictate the matter in court, open court. There is nothing to be reserved or anything.
Yes, yes.
There is nothing to be, can't be reopening the.
No. Yes. At least make it workable, that's all. And only one thing in the judgment earlier, apart from the majority judgment, there are concurring views of this Chandrachud and this CP. And 2-3 passages where the court has taken the trouble of defining what's a terminal condition, because they are concurring views. That will also be the views of the court. So if Lordship can see that also after I finish this. Now,
we can't be interfered in all this.
Lord, this is a chart in landscape where the second column contains what is the original guideline as per this earlier Supreme Court judgment. Now, in reading, I have put what act to make it more workable. But this is a landscape. This is Rastogi, we see this. It's a landscape format.
Why this one?
No, there are two things. What we have done is, I'll explain. One is suggested modifications which are in track, which is in a vertical format. Lordship will just see this from the same block. And has the Lordship got the landscape format, horizontal format? Yes, yes. That is the final thing. In 3 stages. One is the suggested changes post directive. And one is in track, I have given what are the portions to be cut out. And here, I have given the suggested modification. May I read it? Only the reading portion not supposed to see.
How long? Because we don't want to keep Gaurav Banerjee and
Definitely take 30 minutes.
30 minutes.
Yeah, so I think
your matter will come tomorrow. That's all. We don't want to keep you waiting. The rest of the matters will come.
The Lordship is going to dictate also.
Yes. We'll try to close it. Otherwise, we'll dictate tomorrow. There's no keeping it, no question of reserving it.
No.
Yeah.
Are we discharging Mr. Banerjee even if he's interested to listen to Mr. Datta?
I'm so sorry. Always a privilege to listen to Mr. Datta.
But I'm also discussing that arbitration point with him. So very interesting.
Mr. Banerjee, how much time you are supposed to take now? Mr. Banerjee? How much time you are taking?
I have 3 judgments left, the 3 reference judgments.
So that tomorrow we can continue.
Yes, my lord. And I will also address 2 questions of your lordships. One on the 1940 Act, what was the position? And second, my lord, that 33, 35, etc. That's all there is.
Half an hour, maybe. Like we can just time management so that
My lord, those 3 judgments may take longer, my lord. I in all honesty, my lord, your lordship, I've taken only 2 sessions.
No, we don't.
Yes. So, Lordship will see whatever is suggested. If a Lordship approves it, then that will be modified. If Lordship doesn't approve it, it goes.
That's right.
Yes.
Simple.
Now, Lordship will kindly see.
Yes.
We have, as far as the first is concerned, it shall be in writing clearly stating. May I read the second column with the modification so that it will be easy now what has been added.
This is 1.4, is it?
Lord, 198.1.4 are the conclusions, the guidelines. Lordship directed me yesterday that
you're right.
Just make the changes and suggest it because we are not in review. It's not a larger bench.
Absolutely. It shall be in writing clearly stated.
Please read the suggested modification. We'll go to that. So reading 2 columns in reading. Or may carry a greater possibility of harm than reasonable benefit and may thereby cause him pain anguish. Why that is necessary is because the Indian Council of Medical Research published the definition of term so and so. This defines potentially inappropriate treatment or interventions aimed at cure carrying far greater possibilities of harm. I give lots of an example. Now, there's an elderly lady, I'm giving true life example to you. Elderly lady of 1993. She's perfectly in good health. She's carrying on a normal functions, barring slow motion, is movement is slow, etc. She has a cerebral stroke. Yeah, she's admitted to hospital. Now, technically, the clot can be removed by a brain surgery, but you'll have to open the cranium and operate open brain surgery. The doctors advise that look, at her age, it is not advisable to have such invasive surgery where you're going to cut open the brain and do it. The possibility of her sustaining that surgery means she may get surgical shock, she will not survive, or even if survive, you don't know what will be the further complication. So that is the case where she's not terminally ill, she's not in a vegetative state. Right?
So she's conscious.
No, she's not conscious.
Okay.
After cerebral stroke, yeah, I mean the exact example of that I'm personally known to the matter.
That's right.
So, and this has happened in so many families, Manoj.
So that's why we are telling you, if she is conscious, she is able to take a decision independently.
Yes.
You don't need this.
You don't need this.
That's what
No, so what I'm saying
the
is,
important thing.
Correct, correct.
She should have.
Lordship rightly pointed out, all these are cases where the person has reached a stage where she cannot take this thing. And that's why Justice Chandrachud puts the thing of what is called the subjective standard test. That is to say, when the man was conscious, he said that in circumstances A, B, C, D, please don't put me to this. Now he's in a coma. Now he's in a position where he can't decide. So the court says, respecting, because privacy includes personal autonomy, respecting the autonomy of the individual. When he was in conscious state, he chose that I don't want this. So when he's not in a conscious state, please respect his wishes and follow the advance directive. Therefore, I just wanted to add this, that there could be a situation where ICMR calls futility of treatment. The treatment is technically possible, but may not be worth the thing like an elderly patient. And this has happened in more than one case. Another case I know, the person had a stroke. They said instead of opening the brain, you have to cut open this vein and put some stents here. Again, the person was 92 years old. Then the doctors at Madras said, look, it technically is possible, but we won't advise it because the patient may not take the strain of the surgery and it may not, we don't know what benefit it will get after this. Quality of life may not be there after
So
that.
who would do it then?
No, I'm saying,
If the patient is unconscious.
so these patients would have made an advance directive.
No, who would have done that?
What?
This particular treatment, at whose instance would it be done?
The relatives, the children?
So what would they be doing that for?
No, the point is this.
They're just telling you.
Yes, they will be relieved of the burden of taking a call. Some people will say, let us take the chance. Why? Suppose the person is 75 years old.
Are we then proceeding on so many presumptions?
That's why
That
the
there will
general
be somebody who is not, will have to take a decision, he'll be put in a dilemma, and therefore it is put an
Yes,
end to
yes,
somebody.
that's the whole logic of advance directive, that the point is the person makes a choice when he's conscious. That's the logical judgment of, the concurring judgments of this. They go into all this more elaborately. It is discussed the thing. So what we are saying is, we don't want to restrict it to terminally ill, PBS, and this. So we just put it generally, if your lordship approves,
Yeah.
or may carry a greater possibility of harm than reasonable possibility of benefit, and may thereby cause him pain, anguish, suffering, and further putting. So all that we're adding is, may carry a greater possibility of harm than reasonable possibility of benefit. So it's a weighing.
And in fact, in this, we will tell you,
Yes.
some of the amendments to Income Tax Act, which have brought in its string greater complexity, engendered more litigation. We perhaps think, with all due respect to you, that these words in
I'm
red,
not complaining, Guru.
yes,
I'm not complaining.
all due respect to that, or may carry greater possibility of harm than reasonable policy. This itself will become a matter of long debate.
No. This, your lordship, is the last column. This is not my phrase. The Indian Council of Medical Research, on the basis of consensus received,
That is the guideline kind of.
now for the accepted by the medical fraternity. This is not a suggestion by
Is
me.
this the problem which has brought you to this court? The fact that this is actually being kind of a spokes in the wheel kind of situation.
No, we are envisaging what are the end of life situations.
That's right. I'm saying
Yes.
why you came with an MA is some reason.
Yes.
Is this the reason?
Yes.
Because otherwise we are creating a new
No.
what we thought was will it not work with the existing guideline? As far as possible, let us not.
No, I agree. This will.
So let us read that existing guideline once more.
Yes.
Shall be in writing clearly stating as to when medical treatment may be withdrawn or no specific medical treatment shall be given, which will only have, which means what are the medical treatments to be withdrawn, and the treatment which will only have the effect of delaying the process of death that may otherwise cause him or her pain, anguish, suffering.
Yeah.
It covers.
That covers everything virtually.
No, Mr. Datar, the red line part,
Yes.
uh, are we clear in our understanding
Yes.
that since it is coming from the research done by the ICMR and inputs put in, a medical professional will be in a position to understand what it means?
Yes. And this is
Is
where
that what
medical
you're trying to
treatment, Your Lordship, absolutely right. This italicized red link portion should be read medical treatment. What is the medical treatment? If the medical treatment is going to have a greater possibility of harm, then reasonable possibility of benefit, all in the realm of probabilities. This 90-year-old patient may very well survive.
That's
brain
right.
surgery.
So can we say that all the medical treatment, once again use the word medical treatment there,
Yes.
instead
Or-
of,
Or the medical treatment may carry. Yes.
I mean, so that you put
I'm
a
saying
little
no,
clarity.
nothing is lost. It makes it more workable. That's my humble submission. I agree, Your Lordship.
So therefore, the medical fraternity must understand that
Yes.
this is what it means.
Yes, that's what the last column. Yes, Lordship.
It should not be
Yes.
innovation of the court or Mr. Datar or Mr.
No.
Natarajan.
But I will just clarify.
The particular thing
what
is-
I just said. Nothing is from our own suggestion. We have discussed with doctors and there is a complete report of the ICMR which is introduced. Included
It's
in our-
capable, this is capable of getting misused. I think it's much wider the expression is given. May not be scope of review, may not be scope of these particular proceedings. Already everything has been laid down.
Stop it, Lord, I'm
We have to
suggesting I
see
don't
the
like
only
it.
the practical difficulties.
Lord, we spoke to doctors in the evening. They said, please add this from ICMR. You don't want to add it, leave it. I'm not a big quarrel. I'm saying it makes it much easier because there's a medical treatment which has every treatment as a benefit, as a possible harm. So the doctors take a call that in a 92-year-old lady who's had a stroke, who's otherwise not terminal, is completely normal, but now she's not conscious. The possibility of benefit is much less than the possibility of harm causing to her. That's what I'm suggesting. So I don't think anything wrong in including it.
And, like a tenant landlord comparative hardship theory.
No. Yeah. But I'm not, it's not a big issue, Your Lordship. I personally feel nothing is lost by adding it. I leave it to Your Lordship.
What is your view?
That's, it will open up everything.
How-
I don't think it is not in a matter in which the application for this one, the correction or practical difficulties are brought.
What is
It can be examined.
Don't think it's necessary.
Let me say it out aloud, respond to my brother judge. Suppose the element of misuse is left out of our consideration, then this is a harmless thing otherwise, in my, as I look at it. But when we examine it in the context of a possible misuse, then maybe something else will come in.
Let's talk about a primary board. Misuse is taken up by the primary board. Who takes the call? Who takes the call?
See, we should protect the doctor against the potential litigation
That's why I'm saying.
by the, say, next of kin of the.
Lord, that is exactly the reason why, my Lord, I'm grateful.
One another aspect, a clarification cannot lead to
Review.
more confusion.
My Lord, we are trying to solve the problem, my Lord. If we are going to say that we can't add a word or sentence, then it's a different issue altogether. We have met doctors, why we have taken so much of trouble and spent so many hours is that doctors are finding it practically. Please think of the I'm humbly requesting, think of the medical fraternity and think of the patients. Lord, my own friend has gone to Bombay, the magistrate says come at 3 o'clock, come at 4 o'clock, I'm not ready today, I don't have a, that's why I'm saying.
That's a different
Yeah.
matter altogether.
So I'm just suggesting, Lord, why I'm saying.
All right, we will just, we'll consider.
Yes, I'm just saying, my point is,
We have taken note of it.
I-
Next point.
Lord, may I just say something? If it is altering the structure of the earlier thing, then don't accept it. If it is only clarifying or helping
We
it,
understand that. Next one.
next.
I
It may clearly indicate the decision-rich circumstances. Your Lordship pointed out that this is not very clear, so we just added this for your personal Lordship's suggestion. It should clearly indicate that life-sustaining treatment may be withheld or withdrawn if the treating team of the executor determines that it is potentially inappropriate at a time when the executor becomes a patient and loses decision-making capacity in relation to administration of treatment.
Be kept.
This can be.
Very good. Next one.
We will be very clear then.
Yes. Now, Lord, this para 198 So this is very important. 198 point, which is Ravi Kumar also mentioned, that is the most, that recording is the important. The document should be signed by the executor in the presence of two attesting witnesses, preferably independent, and countersigned by the judicial magistrate. We have put attested before a notary as defined in section 2D of the Notaries Act, read with section 11 of the Act. Well, this suggestion was made in the earlier judgment also, but they didn't incorporate that notary. I thought notary is enough, good enough, because
Are you very comfortable with the notarial process?
at least it attested before somebody, madam. Attested before somebody.
Instruction from the government, and so far as this clause is concerned, it can go before any gazetted officer. That would be more
That's what we said. Whether gazetted officer means there are a number of gazetted officers.
notified gazetted officer. That can be done.
No, that's what he's saying. There are a number of.
Any notified.
Any
Lord,
notified.
I remember when Gazette is a nightmare going because officer will, we must know some class one officer,
Yeah,
you
yeah.
go to him, they come in the night. The notary is the best, but in most courts, the notary is
Sitting stroke and gazetted officer.
yes,
That can be.
yes. Because what happens in most courts, notary publics as there, sitting there. You can go there and get it done.
Stroke would be.
At least they'll get some. Personal.
I didn't think of that. So there'll be some sanctity, but it has been signed before a notary public.
What do you say to this?
We have lost the.
Notary or gazetted officer, that would be better. That's what the. Because,
Let it be in the alternative.
yes, that's right. That's right.
You have lost the sanctity of notary now.
Yes.
Notary can come to your residence and put the stamp without the paper being signed.
No, but there are many people who, though there are notaries also, and in every way there is, like medical certificate also, some doctors will give, some doctors will not give.
You have lost the whole sanctity.
So this we make it, subject to what we have.
Flash.
Notary stroke
Or,
Notified gazetted officer.
or gazetted officer.
notified gazetted.
Because in government itself has eliminated gazetted officer in many things.
Yes.
Today, yes.
No, no, from every.
Everything. I remember earlier you have to
Yes,
go and
yes,
contact
yes.
some IS officer, if they come in the evening, go and get it signed.
As a lawyer, every second man will come to you, take my documents to some vessel officer and get it to you.
In addition to this.
Good, the government has.
I eliminated gazetted officer.
Not required. Huh?
In addition to judicial magistrate.
Gazetted officer.
It makes it more workable. We are trying to look at.
Right, we make it workable because suppose the person is not able to move, suppose the person is wheelchair bound, mentally conscious. Now for her to go to the notary public may be a problem. Mr. Nataraj may be right. At least we can request the gazette officer. If he's a known person, he can at least come home and.
Now you have used the word to attesting witnesses, eh?
Yes.
The attestation has a particular meaning.
Two witnesses?
No, no, witnesses, not mere witnesses.
Yes.
Attesting witnesses, it has been defined, as you know.
Yes, yes.
The Evidence Act.
Yes.
The Transfer Property Act Evidence Act.
Yes.
There's a difference between an ordinary witness and an attesting witness. You know that?
Yes, yes. The person attests to the signature.
Animals
Yes.
should be there.
Yes.
And then you should see it, etc. Okay, that is already there.
It's already there. And why the Lordship is right, suppose, just both the Lordship said, what about the misuse? At least if the matter goes to court, they can say, I was the attesting witness, I saw the person sign.
Right.
Next person.
So this is a notary under or a gazetted officer.
Yes.
In addition to here.
So the poor
No,
man.
Lordship, please, my humble prayer is no JFMC. Folded hands and requesting, don't put JFMC. That is the biggest hurdle for this thing to work. JFMC road in Bangalore.
In fact, it will be troubling the magistrate also. We'll be having so many.
Lord, I must say, I'm sorry, I got a WhatsApp received from a lawyer in Bangalore about this going to JFMC. Now, they say, is he going to attest on the judicial side or the administrative side? I got a whole message. What the Bangalore court says, you file a criminal petition. Then the section is saying you're filing a petition, where's the pending matter? And is it an application? Then what happens, I'm told now with all the digital thing, once you make a criminal application, you know, the petition on the criminal matter, it is picked up. So when you go for passport or anything, there's a record that you have applied to the criminal court for some clarification. I got a WhatsApp message from a lawyer in Bangalore. He sent me at night. The JFMC, my humble request.
My brother is concerned about review, modification, whether we are exceeding jurisdiction. That is what.
No, but see, Lord,
concerned
the
about.
point is, suppose the Lordship records that this particular passage is creating problem. Nothing wrong in modifying it, humble submission. Lord, we modify matters so often. Rate of interest is modified. This is modified.
So from the word and countersign, that will be replaced by what you have given,
Yes,
isn't it?
yes.
Then what else is there?
Sorry, my lord, and one more thing in JM Farsi, the magistrate says, unless I get a direction from my chief justice that you are entitled to do so, this is not part of my job. That's another problem they face.
That
because-
can be sorted out by.
No, I'm saying why you just, if you can avoid
It
it.
may not be because he is designated for that purpose by the district judge, by the,
Well, I'll leave it a lot, my lord. That's my biggest request, my lord.
but of course, this practical difficulty that is there, the other question will not, because designated by the district judge, for what purpose, for this purpose. So
Then
the
he-
other question may not.
Then he says you must file an application,
That,
a criminal petition.
that, the other question may not.
I'll let you. No, then not, then once this magistrate goes, not the other paragraphs go. And just for your lordship's consideration, I've given a separate,
Which paragraph goes?
paras 198, 3.3.3, 3.4, they go. Because all are JFMC.
No. So in place of JFMC, the notary public stroke gazetted officer will come.
No, that's coming in 198.3.2.
That's right. We're talking about that.
Yes, yes. No, I'm now come to 198.3.3.
No, we are concerned about and the notary. Okay, you have put notary, we are putting gazetted officer also.
Yes, your lordship is right. That will automatically.
He says as a consequence of that, 198.3.3
No,
and
no,
3.2
just
go.
be notary and gazette.
Yes, as a consequence of that,
Notary or
3.3 and
gazetted officer.
3.4 will go. That's what he says.
This can be done.
Yes.
Lordship is like notary or gazette as the case may be.
That's right. As the case may be, that's enough. Anything else?
Then please come to 198.3.5. The JMC shall cause to inform the immediate family members.
Mr. Datar,
Yes.
point three, digital format, keeping in digital format, can't be shipped to something else. Why to delete it?
Yeah, sorry, my friend has got whatever.
So then
Yes.
again, we have deleted, you're deleting everything, huh?
Yeah, no, one in 198.3.6. Lord, please come to 198.3.6. I'm answering that point in 198.3.6. I'll just finish this, I'll just come. Just
That's right.
just bear with me for a minute. Just please bear with me. I'll finish this. The executor shall inform and hand over a copy of the advance directive to the surrogate decision makers named in the directive, as well as to the family physician, if any. So instead of putting immediate family members, we put surrogate decision maker, which is a term used by the concurring judgment of the.
Family physician has disappeared.
It is there, as well as family physician.
It's there,
Yeah.
but in real terms, it's
Today, very difficult to get a general physician. Very difficult. Everybody is a specialist. If any.
You have said the witnesses and the jurisdictional JFMC, I'm reading 98.3.2.
Okay.
Shall record their satisfaction that the document has been executed voluntarily, etc., etc. Now, where do they record it actually?
In the same document itself, in the same advance directive, they will record it.
This document, because it doesn't require to be stamped and all that. We proceed on the basis.
Yes.
It doesn't have to be
No,
stamped,
no.
number one. So it'll be on one white sheet of paper, we take it. It'll be typed or written or whatever. So overleave or on, wherever there is.
At the end of the document, there'll be attesting witness 1, attesting witness 2, and there'll be notary public. So they will say, or the gazetted officer, they will say that this advance directive has been signed in our presence, and the person and Mr. So-and-so
Full
was
understanding.
full understanding. Because that's the Supreme Court language, we could not.
So we can't change that. Let it remain. So that let it remain. So 198, 3.2 will remain.
Where is this?
3.2 will remain. Let us keep it like that. That is not complicated.
But just let's see this format.
No, let's not see. It's
Well,
there.
Lordship mentioned we have got 5 copies. So since that's the attestation is important.
Then the next is 98.3.3.
Yes.
You have said the JFMC shall preserve one copy of the document in his office that you are going to delete it.
No, I'm going to make a change in 198.3.6. What this is, Rastogi asked about digital format. We have got one suggestion.
No, what you're saying is what is to happen in 198.3.2.
This has to be deleted because James is not there.
There what you're suggesting is that because it is being now done before the notary or the gazetted officer. Now, if it is done by the notary, let him keep a copy at least in his office because he'll have an additional copy. Okay.
Please see 198.3.6, then we'll come to it.
Because otherwise, what will happen? Who will where?
No, like a will, not who keeps a copy of the will.
At least a copy should be there, so it can be counter checked. Eh?
6 format. Digital format.
6.
A copy shall be handed over to the competent officer of the local
No,
government.
second one, the executor may choose.
As to incorporate in their existing electronic health records, if any.
So there's 198, we'll say,
I'm told that there's a national, please inform the court. She's done a lot of work on this.
No, Your Lordships, there is the National Digital Health Mission under which there is, an initiative are being undertaken to ensure that all hospitals have interoperable electronic health records. So if I go to a hospital and I sign in voluntarily with my unique health ID, that hospital will have access to all my patient records, all my past histories, including from other hospitals, and this will be available to another hospital should I transfer there at some point. So what we've suggested is that the most important thing is for this directive to be available to doctors. So once it has been executed, the executor may choose to incorporate it and integrate it with their patient records so that this then automatically becomes part of the patient records and shows up when you take admission to hospital.
whichever
Exactly.
hospital he may be,
Exactly. And this is voluntary. So there's no compulsion.
no
on
right
the
to
executor
privacy.
to do this. And the NDHM has now privacy standards for all electronic.
So where have you
health records.
incorporated that?
So this is under 198.3.6 is what we've suggested.
Is that a government initiative, this particular portal,
Yes, yes.
integrating all the medical records? It's a government initiative.
It's a government initiative. And there are published standards on privacy.
Privacy, etc.
Lordship may say, records if any, as mandated by the National Digital Health Mission.
So let me read that time, 198.3.6, is it?
Yes,
You have added there?
yes, the next page, page 4.
So we have not completed about this 198.3.5.
No, what happened was, Lord Justice Rastogi asked, who will record it, any digital data? So I said the digital data part is coming in 198.3.6. That's why we jumped to
What
198.
about 198?
We can go back. We can go back.
No, it is there, 198.3.5.
Yes. So there, and hand over a copy of to the surrogate decision maker named in the directive, as well as to the family physician, if any. Then the next paragraph is on digital.
What is it? Shall inform and advance?
No, because the Supreme Court said that the magistrate should inform the immediate family members, so that information that so-and-so has signed.
So the executor in place of
Yes.
the FMC.
Yes. So it's not that, at least the family members know that Mr. X has made the advance directive.
Correct. So that will be, now you are replacing it.
Yes, no, what I'm saying is, instead of putting immediate family members of the executor, I have put advance to the surrogate decision maker named in the directive, as well as to the family physician, because advance directive will say, advance requires there should be a surrogate decision maker, like an executor in a will. So I must tell the suppose.
What we die? No, if you say this, if you put it, confine it, that man die, becomes incapable of acting otherwise. He becomes himself a paralytic.
He gives, no, I'm not.
Why do you
Multiple
create-
surrogates.
Huh?
You can list multiple surrogates.
But when you do a will, we put a person who's younger also in. on the-
Why don't you put family members? I mean, normally, when there's a post-date donation of body,
Yes, absolutely.
the family members only inform.
This is because this is the court's own requirement on what an advanced medical directive must.
No,
contain.
court's a family member. Why do you make it surrogate?
No, your lordships in.
198.5 immediate family members.
There is it in the previous paragraph.
This we should think. No, see, 198.3.5, it says JFMC shall immediately inform the immediate family members
You're
of
right.
the executor.
If I may just take you to 198.2.5.
Talking about 198.3.5.
No,
What
there's
my
a
friend
point
is
I'm making, your lordships, that the court has
Not get
said-
too much.
No, no.
We are, I think.
No. What I'm saying is we have only reproduced the paragraph which are going to be changed. 198.2 is not being changed. At page 130 of the judgment, your lordship takes the book.
We have reason to hear 198.3.5.
No, what my friend is saying is, the surrogate decision maker comes from your lordship judgment in 198.2. And lordship said only point out the changes, don't touch other things. So we only highlighted it, your lordship just takes page 130. It
Or
should
close relative.
or guardian or close relative who in the event of executor being incapable of taking decision, in the relevant time, will be authorized to give consent or refuse or withdraw. Not in the concurring judgment of Justice Sikri and Justice, they use the word surrogate. Or can we do one thing, Lord? Lord, can I suggest one thing? In
What
this,
will happen? We are just asking you this question.
no, I'm just suggesting one thing.
Supposing this person whom you name,
He dies, yeah.
he died, what will happen?
No, can I?
What will-
Yeah. No, Lordship will.
And
can I
he
say-
goes into
I
a,
appreciate.
Alternate.
Appreciate. What I'm now thinking is marrying 198.2.5 into this. What we can do now is executor shall inform, as Justice Bose suggested, we'll borrow this language of 198.2.5. The executor shall inform and hand over a copy of the thing to his close relative and to his family members / close relative. Suppose he's alone. He has no family. Family members / close relative, who in the event of the executor being incapable of taking a decision relevant time will be authorized to give consent.
Even then, this is a defective thing for, as it stands, because
If the person
think
dies.
of, supposing the guardian or the close relative died, what will happen then?
Then we'll have to add a paragraph.
What will happen then? And he goes into a limbo. I mean, he goes into
I know.
a coma. What will you do then?
Provided guidelines for where a person loses decision-making capacity.
No. Then Lordship may add a paragraph that if the surrogate decision maker or so and so dies, then the advance directive will not be inoperative merely because the surrogate decision maker has died. That's all. So we can't provide for every eventuality. That's also a problem. That's why we've got income from other sources because we can't prescribe all this. Can I suggest one thing, my lord? In 198 can do one thing. We can say that.
That is why we said that in the name of a clarification, we cannot.
I understand. No, my lord, what I'm submitting is,
One suggestion we are just telling you,
Ah.
subject to what you mentioned. It should specify the name of a guardian or a close relative is what is mentioned.
Hmm.
You can perhaps say it in the plural so that it will work.
okay, and whoever is that, somebody will be alive.
Whoever is there,
Appreciate. Perfect.
this is what we can think of.
No, it'll make it workable, bro. So that we don't have a situation where they'll say this person has died, who can take it now?
When we
Somebody
thought
will be there.
Can be,
Somebody.
Yes, somebody will be there. Lordship.
somebody will be there. Na?
Yes. So what we'll do is, shall,
So we, this can be, you have not suggested.
Or
we have
else
to-
order 5 rule 20.
can I put, bro? Can you see?
Or close-
Take your Lordship, I'm suggesting cut off to the surrogate decision makers.
No, what we will do is 198.2.5, we will add just one S to guardian, making it plural, close relative S. Correct?
But it should be, are they named in the directive?
Uh,
They should be named in the directive.
that's what you're saying.
Correct.
It shall, see, but just,
Your 198.2 will be added with the plural.
that's all.
That's all.
Yeah, just we'll read it out to you.
Yes.
You should specify the name of, instead of a guardian,
Guardian.
say guardians or close relatives to protect him, because even if he says only one, where this contingency occurs, he'll be protected.
Can Lordship say, sir, guardians, can Lordship say any guardian or close relatives?
The name of any guardian
Or close relatives.
Ideally, the person making this declaration, he should inform everyone.
That's what the Lordship.
naming the person who can give the consent. So we'll make it, it should specify the name of any guardian or any close relative.
I'm just.
But again, it will be plural. Again,
Suppose I
it will be
make it
singular.
tomorrow, suppose we make it. Typically, I'll mention my wife or my son or my daughter.
Yes.
Yes, because they'll be the normally people who will be involved in, suppose something happens to the patient, generally immediate family will be involved.
That's right. So, I mean,
Your
because,
Lordship is right, we'll close it, we'll delete this. We'll borrow 198.2.5.
so 198.2.5 will remain as it is. I mean, except for adding this,
This will be repeated here.
uh,
It will be repeated here.
198.25, it will be the name of guardians. I think it should be guardians
All right,
or close relatives. Otherwise, again, it will be singular.
okay.
Any. So we put it any name of guardians, any will go, or close relatives will take over and would be authorized to consent or withdraw. Then it remains perfect.
Yes.
Then you come to 198.3.6.
Yes, but I'm requesting in the light of what Ms. Mehta has pointed out, records if any, you can say that these records shall be, these are electronic records as prescribed by the National Digital Health Commission. That can be added. So it can't be any private record, it has to be only the, it can't be record of say Apollo Hospital or this hospital, it has to be the records as mandated by the
Where,
National
which clause?
198.3.6.
We have to first finish that 198.3.5.
Oh, I see.
We
That
have
your
given
lordship
suggestion.
just now finished.
Huh?
198.3.5,
Ah.
the lordship is striking off this, the entire surrogate and putting 198.2.5 again.
Modification.
So immediate,
With any
Yes,
and
that is the immediate family member.
No, 198.2.5 is, it should specify the names of guardians. Now it's only specifying the names. 198.2 is what the document should contain.
What should be done is,
Yes.
they have 198.3.5 because we have added guardians and close relatives
Hmm.
who are named.
Hmm.
First of all, they should come to know.
Yes, yes,
Most important.
correct.
So
No, but
they should be
be
informed.
informed.
They
Correct.
should be. So we'll have to say shall cause to inform the guardian
Guardians
or close guardians or close relatives
who are mentioned in the advance directive.
who are mentioned in the
Advance directive.
isn't it?
Yeah, exactly.
They should know.
They should.
They are the ones who have to do it.
Correct. Because
Then the other thing can be, and other family members also. I mean, that also can be.
so 198.2 is preparing the document. 198.3 is
But there
informing the
again, we are knocking out the JFMC. Eh?
Yes, completely.
You're putting that responsibility on the executor.
Yes, yes, because nowhere in the world your court is involved. Guardian Act defines who's a guardian.
But if the person concerned is not a Hindu,
No, I'm just defining for God. That's why I put guardians of close relative. Irrespective of religion, we all have relatives. So we don't have to worry whether he's a. It'll be religion neutral.
So here we are just, making it to you.
Yes. The executor shall inform.
198.3.5, we are making it the executor
Shall inform.
cause it to inform.
Yes.
Cause it to inform. Shall cause it to inform let this immediate family members also know. Plus we will add the guardian because he need not be
You
the,
can also say the guardians, close relatives, and immediate family members.
yeah.
Actually, they'll be repetitive because immediate family members are close relatives in any case.
They'll anyway know. That we are not changing that.
All right.
the district judge.
To the.
What about in the case of an orphan? Can we say that he is not having an right to? Whether in that case it is JFM? Because we cannot say that no, he will not be having just because he is not having any close relative. or
You
guardian.
can't deal with every possible eventuality.
And we are only this
Correct.
this right.
No. See, the point is, as far as an orphan is concerned, once he becomes an adult and once he becomes a major, I'm just taking an orphan as a child, right? Now, the orphan becomes old, he starts working, he marries, he has a family. Then he becomes an adult directive.
That is why.
No, I'm saying if it's an orphan and if he remains unmarried, remain anything else, then yes. Then he'll have to put a surrogate decision maker.
Suppose he's a chronic bachelor or a spinster.
Correct, but he'll have a friend, he can say, my friend. My chronic bachelor.
So we're just reading out what we have done. 198.3.5 will read the,
Not one proper, I should mention orphan on a sideline. What is the caste of the orphan? I'm having a problem in Madras. He gets no benefit. Anyway, that's a different issue.
so that we are just adding it 198.3.
Yes.
I'm having this problem right now.
The executor, listen, the executor shall cause to inform the guardians or close relatives referred to in paragraph 198.2.5.
Okay.
And the immediate family members of the executor, if not present, that all will be made. What do you say?
Yes, yes.
The guardian slash close relative slash immediate family member. But the point is, the whole
They should
purpose
know
is they should know about it. That's how they know, that's all.
They will know about it, they'll take in, but then once a close relative mentioned in paragraph 198.2.5 are brought in, And the other immediate family members, is it necessary then?
According to me, no. It's a surplus age. It's a surplus.
Because he would anyway tell.
But just keep it for what it is worth.
Normally, he will not tell his wife.
He did it for positive.
He will not tell his wife because wife will say, okay.
Right. Putting it in plural, does it mean that it should be informed to everyone?
Yes.
No, only to the persons mentioned, the family members, etc., who are mentioned in 198.2, because they are to be named by him anyway.
Only named persons will.
The attesting witness need not be from them. So that this is why this will sort of give it clarity.
Very well.
So those will not be necessary.
Correct.
Correct. Then it'll be guardians / close relatives.
Correct.
To the extent that is what I.
Yeah, that's right. To the extent it's not.
And the immediate family members.
Tell us
also
one thing. But coming.
Then may I suggest for not authoritating
Brother
original.
Judge, who has authored, how much time was spent
That's what
to
I'm
find out
saying. And we are.
that laying down the final modalities.
So let the family members also remain.
Then can I do one thing? Can I say something? Put guardians / close relatives. Forget immediate family members. Close relatives are immediate family members. Close relative itself means immediate family members. Who are my close relatives? My wife, children, etc.
No. The person who
Who are mentioned in the advance directive.
advances should be given notice. So that may not be a close relative. He may be distant relative.
Correct.
We don't know what, what.
Then can also put it this way. The executor shall inform the person named in the
That's
person's
correct.
name in the close directive
Referred
and
to
also his close relatives.
That's what we have said.
Yes. So he has to mention both to the person mentioned therein and also to his.
And what is the definition of close relatives relative in section 56 of the Income Tax Act?
Yes.
That,
The Income Tax Act says lineal
No, that's
ascendants, lineal ascendants and descendants.
that's right. We will have to
Companies-
go to the whole thing then.
Yes. But
So we are reading it out to you so that to make it.
no, and Companies Act
The
defines relative.
listen, the executor shall cause to inform the guardians or close relatives referred to in paragraph 198.2.5 and his other immediate family members
Yeah.
of the executor,
That takes
etc.
That takes away.
That will do.
Yeah,
Then anything
one
else?
second, Vilas. Instead of close relative, near relative may be mentioned because near relative has been defined in the Transplantation of Human Organs Act 1994.
That's a good idea.
So we may mention near relative because this is statutorily defined.
But
in
this
the
is
law.
what this court has already pondered and thought. Let us not, create a complication.
No, I would request, please follow this because near relative is defined in the
I'm
act.
telling you, this is what the 5 judges have thought it fit to. Let us not tinker with it only to the extent that it is necessary we are doing it. Yes. Then 198.3.6, what is it?
Yes, I want your lordship to, I'm requesting your lordship to add at the end of if any, these electronic health records will be those that are maintained under the
198.3.6.
3.6.
A copy shall be handed over to the competent so-and-so, or the so-and-so. You want to add this also?
No. I want to add, instead of putting panchayat, etc., I'm saying if any, I'm suggesting there is a notification dated 30th December 2016, number 1100 of 2015, notification of National Electronic Health Record Standards. So now lordship will kindly just make a statement. Can you put it like this? The electronic health records will be those maintained.
So this is in addition to.
Yes,
Suggestion
yes,
is
yes, because the
not to
digital
do
records.
away with it. Not to do away with what is
No,
already
no.
there. That we don't do. You only want to add, executor may also choose to incorporate.
Yes,
May choose to.
yes.
The advance directive in their existing electronic health records, if any.
If any.
That, what do you say, that can be identified.
If something is available, it's,
That's right, let that be added, we are taking out anything.
let us not make it mandatory or this one, it's left.
It is left to him.
Yes.
So this will be added to this. What is already there, we are not deleting.
No, my lord. The
A
point.
copy shall be handed over to the competent officer. That is a safeguard which has been put by this court.
Who's the competent? Okay, leave it.
No.
Competent officer, the local government means secretary. Who is the person, if you want us to make it clear?
No. Now the point is, The aforesaid authority shall nominate a competent official in that regard who shall be the custodian of the said document. Now, once I'm putting my document in the electronic health records, and that is a statutory notification, why should I again go to?
Who shall be the custodian of that record?
Yes, but I'm saying the government of India is now having, we are a digital age. The government of India is providing for a national
You're
digital.
saying this is one by way of, hard, I mean, not, it's a physical document you're having it. The other thing, you may do it if you wish to.
All right.
So if the hospitals may want
No,
to.
actually, the ulta is the situation. Handing over to the corporation is a big problem.
What is the problem?
There is nobody who nominated.
We'll make it
Not after Vishaka came for 11 years, nobody drafted the laws.
the secretary to the concern, because local department is panchayat, etc., etc. The secretary is usually the
National
executive authority.
Become impractical, my lord. Nobody hands it over to the government. Why do you
There's
enforce the
nobody, what
government?
they say, there's nobody who's competent body.
No, it can be this or that. Additionally, you can put this National Digital Health Mission thing.
Let him do it.
Ah,
That's what he
but
wants.
it could be either. It could be either.
Yes. Or the person may nominate, give a copy if he wants.
Could be either, because otherwise, that National Health Mission thing is ultimately going to work.
That is electronic,
Yes.
electronic health record.
Yes.
And even they only want to, may choose to incorporate it.
No, it's already
What this
notified.
court has found that it should go into the
No,
panchayat.
that's why,
It is-
all right, both.
Both, that's what I'm saying.
Both,
Let
both.
both remain. And if you want, we can say the secretary. Instead of the competent body,
Then can lordship put it, instead of copy shall be handed over, copy may be handed over.
then what is the record?
Why you want a record? Why do you want the record?
Then we'll be completely changing the scheme of the.
Then you can just put copy may be handed over.
No.
Let it be there.
You don't
Let copy be there. It's not working. I'm telling you, lordship, there's not
just handed over.
hand it over whom?
Yeah.
Hand it over to whom?
Secretary, we are going to say secretary and make it clear. It shall be the secretary. Because he is the person who should normally accept it. Can we say secretary?
Going to be
The local
unworkable.
board.
Or else would it be the alternative? Only my thing. Can be some local registrars, there are all the records will be maintained in the registrar office. If it is to be done, I think something can be.
Please don't send them to the registrar's office.
Very likely.
You know what happened.
I know that.
Don't send any one of these people there.
So all the records are normally maintained in.
Even panchayat may not be much different.
But Mr.
You don't
Natarajan,
Yes.
work there.
if this notification is issued,
Yes.
National Health, Digital Health
Yes,
thing,
yes.
it is better you keep it, if it is connected and integrated with all the hospitals.
Coming, we are.
That will be definitely, that will take some time. The process is.
It's already there, notified.
No, actually what happens is the red is only 10%
Just
of the
check up.
whole.
I am,
192
Mr.
is not.
Natarajan is saying it's all
My fluid
notified.
paras are not touched.
We'll check it out.
Lordship sees me not
You know,
to avoid the.
we see, brother. A copy shall be handed over to the, this is something which has been thought of by the default, by the bench. We can add that.
Including so and
This should be retained as
Mr. Datta, I'll tell you one thing. Whatever the exercise we undertake with your assistance and all, nothing can be made absolute. Nothing can be made absolute. So our only request is whatever the difficulty the people have faced in the given point of
Correct.
time, to that extent, we may take a call and clarify. Rest of the thing which has still not made operational, people have not come across those hurdles. Better not to tinker with the moment. We can't visualize how the things on the ground will work. So we want to make it, your anxiety and our anxiety is that it may work on the ground. So whatever the difficulty the people have faced to meet out that situation, whatever the alterations may be.
Yes.
Fit.
Yes, instead of going on imaginary things at
Yes,
present,
that's
as
correct.
in the situation emerges, we can take a call. These are all the,
This court can
it
always.
might happen, it might be the problem.
Simply make a law tomorrow. All these problems will be
The
over.
judgment also it said that the directive and guidelines shall remain in force till Parliament brings a legislation.
Important they say.
So come up with that.
So we are saying this, it will remain, so should we say the secretary? Whether should we say the secretary?
Oh, can I suggest one thing?
What do you want?
Copy shall be handed over to a competent officer of the local government or corporation or panchayat as may be nominated, whoever is nominated, because now the point is this.
That is already there.
No, local government or municipal corporation or panchayat as the case may be.
No, next sentence you please
The
read.
aforesaid authority shall nominate a competent official in that regard who shall be the custodian.
So it's very clear, this court has thought of it. Not as if this code didn't come. So we will only add this other thing, that red will come along with it. Correct?
Okay.
Then next is para 198.3.5 is to be deleted, you're saying. JFMC's role is
Yes, yes,
family physician.
yes,
And that I don't think that can be deleted. Eh?
yes.
Okay, deleted. That is deleted.
198.4.1.
Then 198.4.
Now we come to the implementation stage.
That's right.
198.4 is the implementation. Yes. And there we get, my lord, this is where, my lord, we have, this is with the health secretary and the AMs, my lord, 198.4.
That's right.
Yes. In the event the executor becomes terminally ill or undergoing prolonged medical treatment with no hope of recovery and cure on the basis of Justice Chandrachud's judgment, para 475. He has added 3 factors. If your lordship wants to see that para 475, if your lordship wants to see it, so that it's not my addition. And this is also mentioned in the ICMR record, permanent vegetative, like Aruna Shanbag. Persistent vegetative state. And when you say the treating physician shall assess, this is the primary board.
So you're adding vegetative state.
Yes.
Okay.
But what Justice Chandrachud used, persistently unconscious condition is added at page 475 of the judgment, page 251. Page 251, para 475, 474 and 475.
So you can just add this. Or is being a persistent vegetative.
That brother is saying in that the is in a or is in a persistent vegetative state, we can perhaps consider that. The other portion we can't be adding. We can't be adding it. It requires a lot of thought. You can't be adding it. Or in the state of initiation, you will give so much of discretionary power to the doctor can be capable of being misused, and we don't want that. So now the question is whether we should add or in a persistent vegetative condition. What is your view, Nathraj?
Before lordship
It would be,
decides,
I think that can be.
Huh?
Because he'll not be able to take any decision, and it is
It is covered actually in the earlier.
in the earlier one, it's covered actually.
No, but what do you mean by persistent vegetative condition? Supposing there is a possibility of this being brought back.
Lord, it is defined by the Supreme Court, persistently unconscious condition. Is an
Vegetative condition.
No, same, it's paramateria.
Ah.
Is an irreversible condition.
Irreversible.
Just 1 minute. With no hope of recovery and cure, but
Yeah.
So what will happen if he is in a persistent vegetative condition? The life
Yes.
support system has to be withdrawn.
Yes, because is an irreversible condition in which thought and awareness of self and environment are absent. This is the concurring judgment of the Supreme Court.
From where are you getting it?
Para 475 of the Supreme Court judgment, concurring view of Justice Chandrachud, in the same judgment.
Then you'll be adding to the view of the majority judgment.
No, I'm just trying to, because they
That
won't,
will be basically,
no, but what I'm saying is,
so many.
That are our request.
That is not.
no,
the
but the otherwise judgment is confined to terminally ill alone.
That's it.
What about permanent vegetative state?
I don't know, it should have been done. It becomes a complete revival.
No, it's not revival.
Will not expand, actually,
Dada,
confine only to.
Our request is only one. To the extent the difficulty have been faced in getting particular directions of this court implemented in individual cases on ground. To that extent, because what has been expressed in 98 and all, it is a collective decision of all the 5 majority. And all have agreed to it. There may be suggestions given by other concurring views, but the final suggestions acceptable to all the constitutional benches this.
That's right.
And from here.
Another thing, these conclusions are based on the discussions.
Yes.
Now here, if we are changing the discussion, this decision part only,
Yes,
without any discussion,
yes.
Leave it.
Then we'll go against
Leave it.
sometimes.
We have spent so much of time on deliberations, but if your lordship feel it's not possible for a permanent, not a person like Sona Shanbag, who is not terminally ill, he's in a coma for 9 months, 1 year, 2 years, 3 years. I leave it to Lord. I don't, if it's not going to be, we are only trying to make it as helpful to the patient.
Legislation comes. They also, day in and day out, legislation also come. And the legislator in their wisdom also think that it will work, but will never work on ground. And that's why amendments are made and we also sometimes intervene and shut down. This will always continue and there can't be an absolute system at all.
No, no.
Whatever the system can be made workable and we are able to
No,
get the acceptable results to the extent possible that we achieve the target.
No, I'm only saying we should not lose sight of the forest for the tree. What I'm submitting is, the idea is a person, he makes an advance directive, he is in a position, he can't take a conscious decision. His chance of recovery is completely gone. There is no chance of him coming back. That's why the Supreme Court has said permanent unconscious condition. The ICMR uses the word permanent vegetative condition. He's like a vegetable. He's brain dead. Now there's a definition of brain dead. As Dr. Kishore mentioned earlier, the definition of death was the heart doesn't function, lung doesn't function. Today, the person's heart, lung may function, but his brain dead. The stem is gone. There's no chance of his recovering at all. He can breathe, he can pass motion, he can do everything. I'm only requesting now, since the lordship is modifying, is the lordship changing the judgment? I don't think so.
Make it workable.
Yes, let's come to 198.4.2.
In the chart, my lord, or in the judgment?
That's right.
In the chart, my lord. Yes.
I mean, 198.4.1 to begin with.
Yes.
When and by whom can it be given effect to? Just read that.
In the event, like the lordship asked you to read the original judgment, no?
That's the original judgment. We have to read that.
In the event, the executor becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure of the ailment, the treating physician, when made aware of the advance directive, shall ascertain the genuineness and authenticity thereof from the jurisdiction JFMC before acting upon the same. So now
There are two key elements. One is he becomes terminally ill and with no hope of recovery and cure of the ailment.
that's a terminally ill ailment.
This is how you begin trigger the sort of process. And then 198.4.2.
The instructions of the document will be given, you wait by the doctors. It should be given effect to only after being fully satisfied and the executor is terminally ill and is undergoing prolonged treatment or is surviving on life support and the illness of the executor is incurable or there is no hope of him being cured.
So will it not perhaps cover all this, what you're talking about?
No, the difficulty with doctors face was terminal illness is just one part of where there is no hope of cure. It could be a person who is not terminally ill. He's not ill.
Why were you not able to persuade the court to hold?
But the matter was reserved for a long time. I don't know. We argued all these points. Are written submissions are there.
Oh,
We gave the ICMR. We gave all the directions.
can't help it, they should immediately file a review.
So we may still choose to file a review. That's a different. Take instruction on that. We file a proper review. This one. Only limitation is the problem. Not condone the delay. We can.
Limitation, nobody who will look into limitation. That's a matter.
What do you say?
I don't think we should touch these issues in the
Vegetable
present,
issues?
yes, not in this
Vegetable-
proceedings at this stage.
That was argued.
Not on this application or anything. So actually, we are, I
Oh,
mean,
Mr. Natarajan, we are
getting,
not on that issue of whether review or miscellaneous application or clarification. Ultimately, we are sitting in this combination to see to make it workable,
workable.
not on the technicalities.
That's right.
The jurisdiction is not, you
That's
are
right,
not a
that's right.
jurisdiction, you are in a clarification jurisdiction. That will not come here.
But as and when the practical difficulty comes, we
That
can
will be
think of
right.
that.
That should be right.
On
But
imaginary grounds or imaginary situation, we need not do everything. Even after doing so many exercises, there will be again further, there will be some more
No,
clarification.
just see,
might be
please
required.
see, page 251 of the judgment. Page 251 of the report. Just see that for a minute. Page 251.
Yeah.
Because lordships have held that the law under Article 141 is the law also mentioned by the concurring judges. Now, please see para 474 in page 251. Lordship has got that
251.
of the reported judgment in the SEC.
I'm also informed that the vegetative is a subjective term, it's not a medical term, I am told, by the doctor. So it will lead to a lot of
No, my lord, it's part of the
A
ICM.
lot of,
Yes.
possible.
possible
We don't know.
No, please see para 4. I leave it to Lord. If you want to drop it, I don't mind. These are,
How do you actually define a vegetative condition?
please see para 474 and para 475. Please see that. Kindly see page 251.
No, can I define PVS? Permanent?
PVS, it's a medical
Yeah,
term.
permanent vegetative state is different from brain death, is different from coma. Permanent vegetative state means when the cognitive functions are intact, except the responses. The person is listening. There are eye movement. Person sometimes smiles also. Person sometimes weeps. The person is passing urine. Person is passing stool. Person is perspiring. Person is digesting.
Yeah.
Person beard is growing. So the person is very much alive. The only thing is that his cognitive function is lost to a particular extent of perceptivity. Not even to respond to those perceptions.
So will such a person be able to signify, if not through words audibly, through signs? I mean, please take it off.
No, he cannot. Sometimes
He is not in a coma.
And he can't respond at all.
he cannot express himself. While in the brain dead, the person is dead. He is not perceiving us.
We follow. Now, in the case of a person who goes into persist and a permanent vegetable condition of
PVS.
That's right. Are there cases where they come back?
Yes, they may come back even after 20 years. Because then I have filed a list of 20 cases when I argued the matter before the Honorable Justice Deepak Mishra Sahib.
No, there is a possibility. Why we have asked you that question?
It's a very much viable possibility.
Oh,
Persons have returned even after 20 previous automatically.
therefore, we will.
We cannot say that the person is condemned to die.
That's right. So what are we talking about? We are talking about somebody in his pink of health, or perhaps lesser state of health. He making a call. We taking a call. If I am terminally ill and there is no chance of my recovering, these are the things. Please don't trouble me. I am prepared to go. As contrasted with the case where it's not a case, there is no chance of recovery, as the doctor says. It's possible that he may come. Now, who does not want to live a little longer if it is possible? But leper versus the terminal cancer patient, everybody wants to see a little bit more. Where it will go, we don't know. So,
Well, as it is said, everybody wants to go to heaven, but nobody wants to die.
exactly. So this is a very contentious area. I personally would not want.
Drop it, Mala, drop it.
That is why yesterday also I had submitted that.
What is your stand? What is the doctor's stand about this vegetable condition being added as a condition?
No, clear no, very clear no.
It should not be.
It should not be.
Drop it, Mala.
PBS
Look at
has a very uncertain outcome.
But Indian Council of Medical Research has said it should be a condition.
That is not go there.
Yes.
Because if I
No, let's not waste it. Take a lot of time. Not just put terminally, let's leave it, Mala. I don't want that.
That's already there. So let us drop that.
No,
that is instruction for me also.
Not,
That is instruction for me also.
So it is very contentious.
I took it because the concurring judgment says there are three conditions.
I mean, let us not go.
Leave it.
So that's the end of it.
Yes.
So 198.4, the only difference we will have is that JFCM part will have to go. My learned brother was fine.
Yes. No, and Lordship will say in 198.4.1.
You did not know, notice it. 198.4.1, please read. When made aware of the
I deleted the bar.
the genuineness from the JFC,
No,
that will go.
Next page.
Next page, bottom.
Where,
Page five. Struck out.
Next page,
next page.
Below
there,
page
there
5.
itself. In the black, after red, black. No, next page. Next, there itself. After red, black.
Lordship
Next
is
page
reading
is
the
this one.
Page 4. Please see page 5.
Oh, you have deleted it.
Yeah.
Okay.
May I request your Lordship to cut off that vegetative state there, madam? In that reading,
Yeah, we are cutting it.
Yeah,
out. We are not going to take it.
the entire reading, you are cutting it off. Persistent vegetative initiation, all that your Lordship is cutting it out.
So then 198.4 will, entire thing will go.
No. Only the first part. The treating physician shall ascertain whether the patient possessing. That's part of the health ministry's also guideline that they must have a primary board, secondary board. All that is there.
So, shall 198.4.1.
My lord, earlier what happened? The JFMC.
Shall ascertain the genuineness.
My lord, earlier what happened was the decision to pull the plug was with the judicial magistrate. So JFMC will take a decision on the authenticity and genuineness. Now we are saying the JFMC has no capacity or no time to decide with the genuineness. It has to go to the primary board, medical board. That is also the view of the health ministry.
No, that now the treating doctor will actually find out about the genuineness from whom. If you delete the JFCM, from whom will he ascertain?
The primary board, no, that's coming next. There's a primary board of treating physicians and one independent doctor, the 3-member committee.
What?
Not yesterday, we gave a chart.
The primary board has got nothing to do with authenticity of the
Document.
advanced directive.
That will be done by the primary team now. They will know there's an advanced directive. It will be part of the digital records.
What you are saying is, kindly read 198.4.1. In the event of the executor becomes terminally ill and is undergoing prolonged treatment with no hope of recovery, cure of the illness, the treating physician, when made aware about the directive, shall ascertain the genuineness and authenticity thereof from. This is a sentence which you will have to delete. Shall so then he will, the treating doctor will find out about this. He is made aware of it. Let us see how it imagine it. It's being brought to his notice. This is there.
That's all.
So what this court intended was that it should be made aware. The authenticity should be established from the JFCM that we are deleting. So he should be made aware from about the authenticity of from whom. Because we are actually given that task to the notary or the gazetted officer.
That's only for maintaining records.
No, they are the persons who will be doing that verification. You see, 198 point, kindly come to 198.3.1. We have replaced the judicial magistrate with the notary. So when the treating doctor, he will have to ascertain it from the concerned notary public or the gazetted officer.
Or the close relative also.
Right?
Or the close relative also. What you will imagine, not a person is in the hospital.
That's right.
Now the doctor has to decide, is he going to go to the notary public?
That particular relative is very keen to knock off the
Yes,
problem.
possible. I'm not saying no.
So then how?
So that's why the National Digital Health Record is there.
What if he doesn't make use of that? If not everyone who is
Then there's no directive will work.
so therefore what you're saying is why not we have replaced the JFCM
Yes.
with the other man, that is a notary at your instance.
Yes.
So you can ascertain from the notary public.
Only there's a doubt about the genuineness.
That's it. I mean, that
Yes.
is what,
Correct.
otherwise we will be knocking off this.
That's what I'm saying. So the point is, because if there is a doubt about the genuineness,
Ascertain the genuineness and authenticity from JFCM will be knocked out from
the Lordship is very says that the health team has to go to this gazette office, the notary public, and find out the document is genuine or not.
Going by the decision.
Possible.
This should be done before
We
acting.
might as well close it, brother. It's not going to work out.
This has to be there, Datta. This is a part of the judgment.
How can the doctors go to the notary public and decide? It's not possible.
No,
Not like the Apollo Hospital
I
situation.
was just going to say, suppose you are keeping it in the digital format
Yes,
with the National Digital Health Mission,
yes.
this thing portal, whatever it is. So it would be much easier for the doctor or the treating
Once
team or
it
the
is part
relative.
of this presumed to be valid,
If there is a digital format documentation
it's already there.
with the National Electronic Health,
If that is done.
National Digital Health Mission.
then that is an authentic thing. I
If
mean,
that is done, he need not.
that's right.
But if it is not done by.
So that option should be given here. Instead of, GFMC,
You have to rewrite the whole thing.
no, that could be an additional thing. either here or there.
Not all over the world, all they see is a directive signed by two witnesses. We have to, doctors are saying,
Made aware
trust
of
us.
the one
It's not
shall
that a person is going to be start peeling off.
genuineness and authenticity from the, what we will do is from the, just a moment. Getting appropriate.
But let's see, it's 198.4.2 also before.
So what we can do is,
Yes.
because in 198.3.6, we have said the executor may also choose to incorporate the advance directly in the existing electronic health records. That is done by him. That's a digital thing. He can ascertain the genuines with reference to any existing to
Can I put it like this, Bro?
advance
Can I put it this way, Bro?
entered in the existing electronic health records.
What is the precise thing, just so that it gets?
I just don't interrupt. I'm
Any-
suggesting.
In the absence of the same, the genuineness shall be ascertained from the notary public or the, what do you call it? What is that officer? Gazetted officer. Referred to in paragraph. 198.3.1, 198.3.1. That is what we are proposing. We'll read it out.
Yes, yes.
198.4.1 will read, in the event the executor becomes terminally ill and is undergoing prolonged medical treatment with no hope of recovery and cure the ailment, the treating physician.
What should we say? The treating team of doctors. So putting physician, they should not tomorrow say physician is different, surgeon is different.
Treating physician, there will be one physician at least. Yes. When we are talking about MD and all that, it's not that, it's a treating physician.
Okay.
When made aware of the directive, advance directive, shall ascertain the genuineness and authenticity with reference to any
Electronic health record.
any entry in the electronic, in the existing electronic health record, if any.
Or with the custodian as mentioned in 198.3.
That's it. That is.
Or with the custodian
Or with the custodian, that
as
we can
mentioned in 198.
or with the custodian. So that's the simple thing. Then what else is there?
Now this is the main thing where all of us are agreed upon.
Oh, the main thing is coming out.
No, this primary board, secondary board.
Okay.
Yes. Because in most jurisdictions, there is no board. Because even the concurring judgment says that once I've given my advance directive, it's called subjective second standard. That is, I've already given the directive, so don't now second guess me and reconsider it. But we are putting safeguards that just because the directive don't do, let it be subject to us. In fact, I'm told that primary board is contrary to a principle of advance directive. Please come to 190.
And 198.4.2.
Yes. If a valid advance directive exists, the hospital where the patient is admitted shall constitute a primary board consisting of 3 doctors on the patient's treating team. The primary board shall satisfy itself that the executor is terminally ill and is undergoing prolonged treatment and is surviving life support, or illness is incurable and there is no hope of excellence. You can cut off permanent vegetative disorder. Please cut it off. This is from the ministry, this particular paragraph. That's all. Only, please cut off only permanent legislative statement or is in a
And
permanent.
the other thing also, initiation, escalation, all that will all go.
That's also not necessary because if it's no hope of being cured, that's
That'll
enough.
take care of everything.
Yes, yes, your lordship is right. The whole
So
thing,
bad, therefore, now what is the existing 198.4.2?
there is no board, my lord. So the ministry suggested that there should be a primary board.
198.4.2, 98.5. Instructions in the document are given due effect by doctors. However, it should be given effect only after being fully satisfied with the terminating and so on. What is
Who will
wrong
be
with-
satisfied?
Huh?
Who will be satisfied? So primary board.
Yes.
Because silent as to who will be satisfied.
Without directing. This is matching.
What says is only the doctors, which doctor, there is nothing, it's very ambiguous. Therefore, it is said that let it be by the board, properly duly constituted.
See, that is made clear in the next one,
Yeah.
198.4.3. Because this is kind of a general thing. What is to be done by the treating doctor is, if the physician treating the patient is satisfied that the instruction given in the document needs to be acted upon, he shall inform the executor or guardian, close relative as the case may be, about the nature of the illness. No difficulty. The availability of medical care, consequence of alternate forms of treatment, he must also ensure that he believes on reason whether the person does understand where it's coincidence or concerns. So this is what the doctor, treating doctor should do first,
For which state?
correct?
Hmm.
Then the physician, next is 198.4.4, it is very carefully thought out. The physician hospital where the executor has been admitted for medical treatment shall then constitute a medical board consisting of the head of the teaching department and at least 3 experts from etc. Who in turn will visit the patient.
That's the 198,
So what is wrong with it?
no, 198.4.4 is unworkable.
Why?
It's unworkable because head of department, at least 3 experts from general medicine, cardiology, nephrology. We simply saying, Lord, this the Ministry of Health also agree that this is completely unworkable. Just have a primary board.
What do you mean by primary board?
Primary board is the first board which takes a decision.
What is the composition of the?
Composition is the treating physicians plus an independent person. That's what the ministry says, brother. I have no problem. And as the Lordship pointed out, where is hepatology, where is pulmonology?
I withdraw it.
Review.
My lack of knowledge, that's all I can say.
No, I'm not, these 198.4.4 is,
Why do you say it is unworkable?
that's what doctors tell me, my lord. Now, please see, read it, my lord. The physician hospital where the executive has been admitted shall then constitute a medical board consisting of the head of the treating department and at least 3 experts from the field of nephrology, etc., etc. Then there's a further direction that it should be 30 years experience, all those things are there. We are simply saying make a primary board.
These are all value judgments which have been.
And, my lord, and one more thing, in our application,
We'll change the judge, what my brother says, we'll be changing the structure of the judgment, entire thing. It was carefully, when you said it was reserved, a lot of thought would have gone into it,
I'm just pointing out, it's not
Right.
going to be workable. It's not going to be workable.
Practical difficulty.
So the whole exercise
We
of
want to
the,
make it more easy, more
Lord,
smooth.
well, I'm
But,
saying when
No, one thing,
doctors and this health ministry
is 198.4.4. Such a board, just envisage in any hospital, such a board, just the nomenclature of the board that is given. Try to think of existence of such a board in a, not Kerala, but in a other Mufassil hospital or something. Such a board cannot exist.
No, you will have a hospital where you're going to see, first of all, we are.
No, we are looking at the
We
patient.
are talking about, ordinarily, nobody will do this, first of all, to begin with.
No, that's a,
So we have to begin with a certain socioeconomic strata of people who would want to do this. Let us take it that they would go to what the court contemplated. That they would have this facility. If you want what we can have, they can always call for experts from other hospitals. It is not necessary that the expert from may be working in the same hospital. You see, what you're saying is we are
Lord,
completely.
I want, my friend points out that these guidelines are not only for advanced directives, but also where no advanced directive is made. And I've given in my paragraph, in affidavit, I've given 7 paragraphs why this is not workable.
Well, then constitute a medical board.
Yes.
And so consisting of the head of the, let us go step by
No,
step.
no, that's-
Let us- Head of the treating department will be there. Every hospital, if you are going to have some major, if you are going for oncology,
I mean, if you're,
I'll give you an
no,
example.
because at least on this point, ministry also wants change, my lord.
We are not going to think that the ministry is always.
No, I'm saying this is thought of by the
What you
games.
kindly take,
Sorry,
bear with
my
us, kindly
apologies.
bear with us.
Okay.
Let us read together. Shall constitute a medical board consisting of the head of the treating department. Okay. Now we are talking about a terminal illness, no hope of cure. I mean, no possibility of cure. Now let us take oncology. You are contemplating a situation where the oncologist, there will be a head of the department. There will be somebody who in every hospital will be designated as the head of the department. That person will be there. So then comes.
But in many hospitals, it may not be department, it'll be just hospital, 3-4 surgeons. Go to a hospital, 30-bed hospital.
You should go to a hospital if you want to get all this. You should go to a hospital.
No, I mean, if we go to a hospital, I will go to a nursing home which may not have heads of department.
Then what should you? How would you verify all this? If you are going to say, I want to get, no, if you want to say that I want to get the benefit of the judgment, and I go to a nursing home where you just have an MD.
No, I'm saying you may not have departments of oncology, neurology, cardiology, that's what I'm saying.
Get a doctor from outside. We can make that clear.
No, but
Is that,
no,
we are
which-
telling you,
which
find
doctor
something
gave it?
inconvenient. You're taking away somebody's life support virtually. You're going to say that please make it even more convenient so that I can go.
Take
I'm
away
not
the
saying
life of
that.
some other,
I'm saying that,
so that I can take away the life of some other person.
Some other person.
I'm only saying
What
primary
is
board and
that?
review board.
Is he correct in saying,
So I'll show that,
what is your suggestion about it?
Actually, the department wanted to have board in a particular place. Board should be there instead of giving a very vague expression that it should be by the doctors. See, they wanted it because we are, I mean,
That's right, the health condition
Yes.
requires a multidisciplinary
yes. In
examination.
different conditions, different situations, we can't visualize at this stage. Therefore, they wanted a board, that's all.
That's why the court also thought of a medical.
Yes.
So that they should go to a hospital where these facilities are available.
Yes.
You cannot simply go to one clinic and say that this.
We can't, yes, we can't do it.
To get the benefit, you will have to go to such a hospital.
It's a hospital.
consisting.
But-
Because the thing is that you are actually taking in the life of one person.
Correct. You are taking away somebody's life.
So like-
No light.
continue tomorrow.
No, you continue today.
Okay, please.
My brother agree for some more time we can spend so that we can maintain. If you are agree and close it.
You see the entire list.
Tomorrow anyway, we don't have any.
No, no, it's not saying that. Right now it is 4:30.
Take one. That will be over. That's all we want to know.
The suggestions are ready. Definitely it is going to take another hour. That's what I feel. Because it's a,
You want to go
no,
somewhere?
no, I have no problem. I can sit on 6 or 7. There's no problem. But
Suggestion in this particular.
That is, doctor, you have given very invaluable suggestions, including particularly the vegetable condition. Your suggestion was very crucial. So let us first be done with him and thereafter we will consider.
What is the list number?
About this medical board, do you have anything to say?
Yes. I'm talking only precisely on this particular point. So the medical board should be of 3 doctors.
Yeah.
Number 1, the treating physician.
correct.
Number 2, the superintendent or the director of that particular hospital. And number 3, a specialist from the specialty concerned. Suppose there is a patient suffering from carcinoma, we can call an oncologist. If he is suffering from renal failure, we can call a nephrologist. If he is suffering from neurodegenerative disorder, we can call a neurologist. If he is in deep jaundice, we can call a
I'll
hepatologist.
give you a practical example. I'll give you a practical.
Even the practical example, only 3%.
No, doctor, I'll tell you, give a practical example. I know there's a hospital in Kerala where I used to go. That the medical director, he was a MD in medicine, but he went and studied in CMC Vellore, passed out of Vellore. Supposed to. He was designated by the hospital as a medical director. He was not a super specialist at all. In most hospitals, you find, even present man I know, he's a ideal MD in general medicine. Maybe maximum exam DM. Correct? Now, if the treating physician is also an MD in general medicine, so you will end up having, out of the three, you will have 2 persons with MD in general medicine. So the whole point of having a multidisciplinary board, which was in the mind of the court, that will be lost. You see, when you talk about a genuine multidisciplinary board, the whole idea is you're taking a very vital decision affecting somebody. So they wanted this court intended that all these disciplines are those disciplines where you could have the possibility of a terminal illness becoming so bad that you need to have all these relief. So that is why, I don't know whether you should tinker with it. You can add something more or something.
I think doctor's suggestion of having a team of 3 doctors makes more sense because it simply says the treating doctor.
Not the medical
General
director.
hospital.
Not the medical director. You may have nothing to do with
Depending upon the terminal ill.
Milord,
What is the terminal ill? That we will have to.
No, because we want
What kind
an
of-
odd number. An odd number. One is the treating doctor. I'll put it this way, Lord. Typically, if a person is having cancer, now if he's in a reasonably good hospital, he'll be treated by an oncologist.
They want the board.
So already the treating physician is an existing
So he'll
oncologist.
be the head of the department.
Yes, so what the ministry also suggests,
He'll be the head of the department.
may not be, he may be a junior doctor also. We don't know, a large hospital. He may be a junior, I may have, a large hospital may have 5 oncologists. Everybody may not treat me. The senior most person may not be treating. So,
So if a junior doctor is
no, we are just talking about safety mechanism of safety.
if a junior doctor is treating him, it will be very, very unsafe.
No, I'm saying he will be 20, he may be 45 years old. He may not be 60 years old. He may not be the head of the department.
That's right. But
Yes.
if you have somebody with greater experience,
Yes.
he will take an independent look at it. See, the treating doctor may have a particular view.
But this 194.4 is not going to work because you can't have because time is of the essence. The person is terminally ill. He's brain dead. You
Many
take
of the major hospitals in Chennai, you're familiar with Bombay, and you say that this will not work.
But we're not doing for, not meant for the big hospitals.
No, I just want to say, I come from the northeast part of India. I can visualize only the Guwahati Medical College and 2 other medical college having this kind of a
Throughout
situation.
Northeast.
Correct.
Throughout Northeast.
Throughout northeast, other 6 states will not have,
Uttarakhand also is like that.
not a single hospital
Uttarakhand
in the government sector also. So therefore, this is not
Sorry, but many people are coming. Lordship's perception, it's only by a small class. Many people would want to do this once they know it. And the Lordship sees in many towns also, there are chartered accountants. Even in a small town, there is a chartered accountant, there are advocates, there are professionals, architects,
who want to be.
who can take advantage of the advanced directives.
So they should go to that appropriate hospital.
Not to a clinic and then
No, no, I'm-
take away the life of a person by sin. So you will have to visit to a particular hospital where some such facility and doctors.
Just imagine a junior government servant, his father has a cerebral stroke, he's terminally ill. Now, are we going to tell him that, no, if you want to have this advanced directive, you must go to Apollo Hospital? and
Not
go there.
Apollo, not Apollo.
Government hospital.
These facilities, we cannot say that these facilities are available only in Apollo.
No, but I may say, let's say, for example, suppose I'm staying in, say, GK, Greater Kailash in Delhi. My father has a stroke. I take him to that local hospital where 25, 30 beds are there. There is a team of physicians. He has made an advanced directive. They don't have a team of oncologists, nephrologists, they don't have. They've got a team of doctors who are doing it. They get treated. Suppose it's only a cancer hospital. They have no other department.
Datta, when you say,
The point is, what is the purpose? What is the
That's right,
purpose of it?
that,
We are having a prime.
Datta, you kindly come to 198.4.4 once again. Does it anywhere say that the members of the multidisciplinary team should be of that particular hospital?
It makes all the more difficult.
No.
Please see
You're saying it.
please see the
that
feedback of the doctors.
Ordinarily, you would, when you go to a particular, when you're talking about terminal illness, and you're diagnosed, you're getting this treatment, It will be in a hospital where these facilities will presume it is not. We assume it is not there. We are
Suppose I'm
telling
in
you
a
we are correct.
northeast state, sir.
So we are correct. We'll assume it is not there. Just see what it says. A medical board consisting of the head of the treating department. I think that there's no difficulty with that. And at least 3 experts from the fields of so and so, so and so, so and so, so and so, with overall standing, who in turn shall visit the patient in the presence.
Correct.
Now, they would not be drawn from that hospital. We are trying to tell you. If you want, we can clarify that.
I've got 3 affidavit. Doctors have said this is not possible because suppose I'm
They don't want to call doctors from outside.
but they have to leave their work and come here. The 4 people must come. They must come at a particular point of time. But I'm just saying, let us see from the perspective of doctors, not from what we hear.
One thing I suggest, Datar, if you think, if we reduce the number of members of the board, make it workable, one thing. The treating doctor and 2 other experts to have a board to examine,
And that's the primary board.
primary board. Leaving apart oncology, this. Expert means the director, the person who constitute the board, keeping in mind who are the experts in the relation to the sufferings of this patient. And accordingly, board will be constituted. Not possible?
I'm telling you,
Oh, yeah.
Justice Joseph is asking you can call doctors from other hospital. I'm looking at a scenario where in the entire town or the city, in a given hospital, this is not available and forget about getting somebody from outside. Experts are simply not available. I'm talking about a scenario which I am familiar with. It may not be replicated all across India.
And I am also suggesting to myself, if a person has got say 15, 20 years of practice, I mean, any good doctor, anybody knows that this is a person who's terminally ill. Suppose the cancer report says he's got the 4th stage. It has metastasized. It has gone all over the thing. Then do we need 4 doctors from 4 teams to come and opine and all that?
We do not know.
That's why they say terminally ill. That's why they say terminally ill.
Well, the decision is also very
No,
critical.
the point is, how should the board be?
Taking
That's the only
this-
question.
And why should we also distrust the doctors who will be opining as to the condition of the patient?
Please see the affidavit which you prepared, Vinod. I spoke to doctors from Bombay. I spoke to a panel of doctors from Madras. They had a meeting in my office. I went to Madras Medical Mission. I spoke to the doctors. We took all the trouble.
So
They
what
say,
is
look,
this?
it is impossible. Even in Apollo Hospital, where do you get the time to call all the team? They will summon the team. Director will come. Everybody will come. They will meet. Then you get a further report. It's not possible. And how many people go to Apollo? How many people go to big?
Task is a serious task also.
Can I suggest?
Whether make
Let
somebody
us read
leave or.
once again.
Sorry.
Mr. Datar,
Sorry.
let us read.
Apology.
The physician stroke hospital where the executor has been admitted for medical treatment to a medical board consisting of the head of the treating department and at least 2 experts from the field,
Thinking must have gone. Yeah.
then leave it with overall standing in the medical profession
Change all the
of
directives.
profession, who in turn shall visit the patient. All these
20 years, etc. is gone.
So leave it and have a trust
To that making.
on the person who is constituting a board to make it workable and meet the requirements.
Then we need not have a review board. Then one board is enough.
If they want.
Otherwise, we'll just go on here and there.
No, actually, when I discussed with the doctor, suggesting, suppose there's a board like this, should you have a review board? One viewers don't have a review board because the primary board has taken, that's enough. And the patient has said, allow me to go with peace and dignity. Only thing what the ministry's suggestion was that since you're taking away a person's life, let that thing be reconfirmed by one more, like a review.
Some second balance.
Second.
Why don't you have a,
Yeah.
at least executive instruction pending? Then it will have a status of law.
Take away somebody's life.
Instruction is that there should be 2-tier.
Often that Justice Desai has to say that above me is only God.
Instruction is that there shall be 2-tier check.
So what do you say about this particular clause, 4.4, about the composition of the board?
composition, the instruction what I got is a board comprising of 3 subject experts. That's what they say.
3 subject experts.
Subject experts.
That's it.
It's,
That's all that the court will also
yeah.
say.
It's a
And subject expert means who? What subject?
subject depending upon
Where
the
the illness of
illness.
the patient.
Illness.
Relevant
Ailment.
to the patient.
You put subjects and all that is critical.
No, relevant to the patient.
Obviously,
Obviously.
you have to trust somewhere the person who will be called upon to constitute the board. He will constitute the board in reference to the subject which the patient demands.
So they will call the anesthesiast,
No.
head of the department,
And
and they will call, if, it can follow.
The doctors have repeatedly
What
said, you please trust us.
what you're asking us to do, mind you, because it will apply throughout the length and breadth of the country, there will be a lot of people who can be taken for a huge.
Your lordship,
Please just to be reminded, I'm telling you,
I'm not, I
with all respect to you, we are telling you.
yes, but also the point is, this advanced directive is there in multiple countries.
You don't come,
No, I'm just telling you, lordship.
don't compare.
No,
I'm
I'm just,
talking about the Western countries.
I'm talking about
Yeah, where in India it's capable of being misused. That is why they spend so much
I'm
time.
asking, but I'm asking myself, how is a person in Bombay different from a person in London in terms of hospital care? People are coming here for treatment. So I'm saying misuse may be in the villages where the person is illiterate.
this,
And what the doctors are saying is,
Yes, let us hear.
and one more requirement which is suggested was that in the primary board there shall be one gazetted officer
Ah,
who shall actually he should either record his satisfaction that it was being done by the board and he shall be part of that board.
oh, my, that will be adding in.
It is required. That's what they say. Because tomorrow that particular board, if it takes some decision or anything, there must be some kind of authenticity for that.
That is not bringing more bureaucracy. May not be, will come, what you want about this is, what you say about this 4.4.4, 198.4, you are saying, what are you saying? In place of this, and at least 3 experts,
Yes, 3 subject experts.
okay?
Yes. 3 subject experts and 1 gazetted officer at least.
So,
That's
what
what
I think, this is Rastogi suggests very practical.
what we
The
can do,
doctor plus 2 more experts is enough.
2 more experts in the relevant.
Leave it, just say 2 more experts. Let the doctors apply their mind. Let's trust the
2 or
doctor.
3 subject experts.
Two.
Subject experts.
2 more
Treating physician
and 2 more experts.
and 2 more.
They have somebody in the
You have to
relevant
keep in
field.
odd number. Board has to be constituted always in odd number.
Yes, so treating physician and 2 subject experts. Leave it at that. Let us see how it works out.
As far as possible.
Of at least 20 years, and that also you want to knock out. Not necessarily, 10 years sufficient.
But then why 20? Why not 30? Why not 10?
No, that's what the court has found.
That's what I'm saying. It's not practical, but the reason why we have taken so
You
much of
don't
trouble
find
is,
anyone with 20 years experience in anywhere in India.
but suppose the person is 18 years, the one doctor is 18, suppose the man of 22 is gone on leave. But
So that are considering our jurisdiction.
yes,
We are not a reviewing court. To what extent we can tinker with the directives,
no, but the point is,
the substantive judgment,
no, the point is,
which is.
if it's a board, if it's a medical board, you can always modify the medical board in the light of experience.
So
There is-
where is the
because-
study that?
Yes,
is
my
not
affidavit.
workable?
I got 8 pages of affidavit.
That's
So
my
you-
own.
Even the views, number of experts from 3.
He is also an expert. In law with 5 years also equally an expert.
Even one day is expertise.
No, but in fact, there's
At least they have
something said,
At least they are learned friends.
That's right.
With 1 day experience also.
They are not-
They are learned
no,
friends.
in fact, somebody said, when you say 10 years experience, it is the same 1 year multiplied 10 times. He's not done anything beyond. So that's a part. I'm just saying 20 years was unworkable because sometimes why keep it 20 years? Keep 3
What is
experts
the
and leave
view
it.
of the court? 20 years. 20 years. 20 years, what is your view? It should be. What is your view about 20 years being knocked out?
I'll not be able to have it executed.
No.
If I remain in my part of the country, I'll not be able to have it executed.
You don't remain the middle.
That I don't know.
So what is your idea?
It's unworkable actually. 20 years.
You see, We have to leave.
Now, why should we think that somebody with 20 years experience is in a position to know the condition of the patient and somebody with 10 years experience is not in a position to know?
Fixed period should be. Having listened to the.
If there's a rationale for 20 years, one would
That's
stick to it.
because of, the proportion it bears to the importance of the, the decision you are taking.
What if I say 10 years, if an advocate can become a judge in 10 years, why not? Doctor in 10 years become an expert.
So there are practical difficulties in some of the remote village areas and all to get the
You will not
more
get 20
experienced
doctors.
doctors. That is the one thing they thought of. And
Because those who are super specialties,
You think there's somebody.
they become
who is going
super
to do all
specialties.
this.
Tata, if I'm
nothing is going to happen in this one. That much
My
I can
experience goes.
tell.
They are more concerned with
Super
having a
specialty doctors
physician
come
there.
at the age of 34, 30, 33, 34, 35.
All these courses.
Super specialties, yes. Because so many problems are there. So by the time he has 20 years experience, he is 56. Doctor, sir, correct?
Yeah, you are right. You lost me, right?
So by the time he has specialty with 20 years, his age crossed 56, 57.
That is why.
Your the diagnostic acumen, the professional expertise is not related to the years that one has passed after obtaining a degree. Institute of the person. The person. Why do you specify the number of years?
You want to make
Okay.
it 1 year.
No, I want
Yes,
to
that
use
is
the
valid.
person who is constituting the board.
Yes.
Subject experts will do.
There should be no,
Why? What is?
no mention about the year of you.
That's all. If you want to.
It's not a word.
You had introduced yourself as I am having so many years of experience as a doctor. That has its value.
Rajan, what do you suggest?
Amendment of conscience, if you decide, make it 15 years. it may be-
Criteria, not.
We are only putting the problem on the medical field. If we are going to say it's a judgment, we will not change it, then it's a different.
Now, Rajan is the arbitrator.
Again and again, we are thinking.
No, but please, look, this is not a judgment like a law which can't be, we are talking about human condition.
Again, we will have to think about one thing.
Yes.
5 London judges, see, they must have spared so much time. And they fixed it
Yes.
and now,
You're diluting it.
Yes, but now what is
and
happening?
also we will have to take it up.
Now doctors have now said that please don't put 20 years. Please don't put judicial magistrate.
That we have
That's
understood.
why,
that is-
wherever it is
15 years,
possible.
Okay, put 15 years, now leave it, now let's not waste because.
That's right.
Yeah,
You know, I have worded it in a very simple manner.
Ah,
All controversy will go.
ah,
I'll read it.
ah.
It's 2 lines. The final decision of withholding treatment should be vested in a committee comprising of the treating doctor, the superintendent or director of the hospital, and a medical specialist of the concerned specialty. Now, I would like to define what is specialty. Nowadays, we are talking of subspecialties.
Super specialty.
So, and I have not mentioned subspecialty. Oncology is a subspecialty. A surgeon is also removing a cancerous growth. And a general physician is also treating a patient of jaundice. Everybody need not go to a hepatologist. A person who is in MBBS, he is also treating urinary tract infection. Not that everybody should go to a urologist. So this concept of subspecialties is contrary to the general theme and philosophy of medicine. Because firstly, the subspecialty is simply a part of the medicine. I have been taught, even before I did my MD in radiology, I was taught about radiology. It is simply a matter of refinement of my knowledge. So a concerned specialty means if there is a growth in the breast, a surgeon may remove it. So that surgeon will see. Number one. Number two, all the board has to certify is that whether the illness is terminal or not. He is not under obligation to diagnose it. Terminal illness is a clinical condition. And that will be there very clearly visible to any specialist. So we have to certify that the patient is terminally ill. He does not have to go into the diagnostic aspect, fine tune the diagnosis. That is already there. So 3 doctors are sufficient. Now, why I included the administrator of the hospital? Because there is an executive dimension to it. So he will be knowing whether all documents are in order or not, whether all necessary legal formalities have been completed or not. So it has got an administrative angle also, while withdrawing or withholding the life support. And that is, will be the person in charge of that hospital will be the ideal person to take count on this.
So what we can, after hearing, what we can possibly do is to have consensus. The physician hospital of the doctor where he is being treated shall then constitute a medical board consisting of the head of the treating department. We take it that you have no difficulty with that.
No. Treating physician.
Not head of the, just treating physician.
Treating physician.
Not head of the treating physician.
Not the head of the department. The physician who is actually taking care of that case.
So the treating physician,
Then
the treating physician, just let us try it. We are trying to find out. Treating physician, head of the department goes, say the treating physician. And at least.
the superintendent of the hospital or the director of the hospital.
And at least 3 experts.
Superintendent is director of the hospital.
No, don't bring the
The
superintendent.
head of the unit,
Don't bring the superintendent because he may be having nothing to do with the particular disease.
Documentations.
Documentation.
documentation, or even formalities.
So his expertise may not be of that use. You can have him as an additional member, that is okay. But otherwise, what this court intended was, not the person who may be a medical director, for example, he may be the one who is actually running the hospital. He may be the businessman. He may be the manager, he may be the director of the hospital because he is running the hospital.
Ultimately, if I may say so,
Don't do that.
no, what the Supreme Court wanted was, before somebody's life is taken, it's an informed, thought out decision.
He will inform the family members and everybody. He has to discharge administrative functions also.
There has to be many layers of decision making.
So there are several layers in the decision making. One is the clinical decision making. Another is the administrative decision making. So one administrator, because
Can be that medical director can constitute the board. The medical director can constitute the board. But he should not be a part because, we can point out hospitals where the person who is just barely the past year because he is running the hospital.
Or the son of the founder.
Son of the founder, I can give you,
Yeah.
if you want. He's become the director, it will be catastrophic. Yes.
No, Lordship, his simple point is, the treating
So we are
physician and 2 other subject experts, as Justice Rastogi pointed out. that's
Not
all the-
not two other. There we'll be completely tinkering if you make it 2 other.
Yes.
Let it be 3.
belong to the
Or and make it cheap.
transplantation of human organs and
And
certified brain death.
And at least 3 experts from the relevant.
Lordship, at least 2.
Relevant fields of medicine.
Correct.
Instead of, confining it to this.
On it.
Milord, when in the transplantation of human organs, when we certify brain death,
Whether
this is the combination.
Lordship, just see, my learned friend
they
is.
are having a
or my
conference,
colleague.
you don't bring the conferences.
Sorry, sir.
Treating physician. The physician shall constitute the medical board cannot be. We will make it the medical director. The medical director of the hospital, wherein has been admitted for treatment, shall then constitute a medical board consisting of the treating physician and at least 3
Subject experts.
experts
From the concerned specialty.
Yes, from the concerned specialty.
that can subject experts of the concerned specialty.
It is specialty. Specialty is a generic
So
term.
what about this? And at least general medicine, etc., that will go.
All go, not miss it.
Because there is an end to it. You see, it says with experience in critical care. That will go there.
Critical care, no need. Concerned
But you may not have
specialty.
ICCUs everywhere.
Treating physician. 3 experts, at least 3 experts from the concerned.
Concerned specialty.
But the only thing of 1 plus 3 becomes an even number. Odd is always better. But anyway, lots of
So
make
we may put two experts are sufficient from the concerned. Why 3 experts?
Why 3 experts? How will they add value?
Concerned subjects.
Yes. Lordship is a treating physician plus 2 subject experts plus 2 doctors
Not 2.
Two.
Plus 3 experts from the concerned departments.
from the concerned specialty.
Speciality.
Concerned specialty.
That will be very clear.
Yes.
You will have elasticity also in that.
Yes.
Then
No, it becomes.
with
it
experience,
becomes
what do you
a-
say about that sentence?
even
Because
number.
we have to make it
No limit to experience.
with experience in critical care and overall standing in medical, at least that will be 15 years. That will remain with experience in critical care. Should that be there?
No,
No, no.
not necessary. Not necessary.
Board has to be a 3-member board. It can't be.
This is what you said. Some reason which we don't know. Some mystical
This
reason.
this is at least three, my lord. So it can be 5, 6, 7.
Normally, board is to be.
You have said
of-
at least 3. You have said at least 3, which means you can make it a 5.
No, no, we want the board to be as small as possible. You don't want it to be expanded.
You want to make it a 1-member board.
No, no, no. I'm not going to extreme. I'm just saying that 1 plus 2, a doctor says, physician plus 2 more people, 3 minds are enough, not like it's like a 3-member bench.
Is there any reservation of odd number?
I don't know. Treating physician plus 3 members will come. So what will happen is that he will also chip in with, because he anyway is part of the team. He'll say, what is it? And then comes with, we want to know whether we take out with experience in critical care and overall standing.
Yes, that should go, my lord.
So this with experience in critical care should go.
Go, and
that
overall
means,
standing, 20 also should go.
What is your view, doctor?
There is no need of critical care mentioned.
And
Because
20
the person is terminal illness is always critical.
Told not
No, no,
required.
the person-
Certified.
the person who's terminal is always critical. His point is well taken. If he is
Yes.
terminally ill, he is already critical.
For that, would a critical care expert would not be necessary.
Not necessary.
Not be required. That is
Doctor
instruction.
knows that he's not going to
Not be
survive.
required. That is instruction
As per
from the department. The
what
concerned.
does it say?
Not required that to be that.
Do you know that there is a course in, medicine with the critical care? They study critical care.
I have no idea.
They do study.
Yes.
The doctor knows.
Yes,
We don't.
They specialize in critical care.
ICCU.
Yes,
I know.
yes.
But the point is the person is having got 4th stage cancer.
Critical care is a specific term. Terminal illness is a generic term. Critical care is included in terminal illness. Everybody who is critical.
So then what should, and then ideally what we should do is this. We should have this treat the 3 experts from the concerned specialty, out of which one shall have knowledge of critical care.
Yes, sir.
Then
It will become unworkable.
Unworkable, unworkable,
why-
but unworkable, not
Critical
possible.
care conditions are not there in
Not
many of
there.
the hospital.
Not there.
Many of the hospitals.
But critical care is ICCU. How many wards are ICCUs?
I look at it this way as a doctor who attend a meeting of this kind,
Yes.
because his priority will be the patient that he's undertaking critical care of.
These are the practical imperatives.
No, but
There's a reason.
the place where this patient is taken, if we are talking about withdrawing life support,
So we don't need a critical care expert. Not
presumption is that that hospital is equipped with a life support equipment.
When you talk of critical care, it talks about ICCU, ICU, advanced.
ICCU?
This is the-
Where else you will find a life
No,
support
no, the point
system?
is who will certify that his life can be taken away?
We are on a different trajectory.
Yes.
See, you are talking about withdrawing life support system.
As per the wish of the patient.
Yes. So the place where the patient is taken, presumably will have a life support system.
Not necessary. He may have 4th stage cancer, he may be brain dead, he may
We
have
have
an accident.
tried to accommodate so much. Now you come to 198.4.5. You're saying it is deleted. Just see 198.
Yes, because the point is, because the whole thing, as per the ministry's instructions, there is a primary board, there is a review board. Therefore, we said if there is already a primary board, then the second board there cannot be another hospital medical board. And this is the board by the collector. The collector has to constitute a medical board. That's not possible. 198.4.5, where the collector has to constitute a board consisting of the CDMO and all that. That's not possible.
Counter check. The
Not
counter check, are you saying, Nataraj, what do you say? They're saying that the second board need not be there.
The collector need not constitute the board.
Who will constitute the board?
No, the collector did not come to the picture.
So that's right, but then should not there be a second board?
Hospital only constitutes a review board.
Review board consisting of which member?
Board is different. But second.
According to us, review board is not necessary at all.
So.
Yes.
One by one.
No, because the point is one board is enough. But if you want a review board, if a collector is going to constitute it, is an impossibility. We might as well then end of the matter.
Correct. So let's clear what is but no sir. What do you say, Nataraj?
Yes, I'm told instead of the board by the collector, there will be a separate review board that will take care.
A review board means what?
A review board comprising of 3 physicians from the relevant discipline.
From which hospital? From the same hospital?
That's not
If
specific.
available,
Yes.
otherwise.
If available, or else you have to get from outside. That's
See,
it.
let us see, they look at the, like,
No, but not.
Not including that treating
Yeah,
doctor,
he-
excluding the treating doctor. He shall not be part of that review board.
huh?
Treating doctor, he shall not be part of that review board.
That's what a treating
Second.
doctor-
Independent team.
And the very same team, if they give a report, what is
It
it?
is, yes, correct. It must be totally independent.
So that, who will be the doctors of that board? And will it be from the same hospital or from,
So,
From different hospitals,
Huh?
from different hospitals, not from the
Exactly.
same hospital.
exactly, that's what you're saying, therefore it has to
That's why
be from a different,
hospitals
it has to be from a different
From
hospital.
different hospitals.
Huh?
From different hospitals,
Exactly,
from the same hospital.
correct.
exactly, that's what you're
But there
saying.
is no need of a review board. There is no need of a review board. Once there is no substitute for trust. The decision
Not in this matter.
dealing between doctor and patient.
Then we
is
will
based
be
on
completely
fiduciary.
knocking out the basis of the judgment.
That's a technical point, but as a doctor, no, became that there is no substitute for fiduciarism. Trust. People have handed over body to me and I have used knives on their bodies. So there is no documentation. It's a trust. So if a doctor says that the patient is terminally ill and there are no chances for him.
Right?
Subject to one thing, subject to what is compound. Since we want to consolidate first board and the review board as one board, let us have a broad-based board so that it may take care of
Good point.
all the nature of casualties or one board,
Yes.
broad-based, so that they may take decision one for all.
Or let me a 5-member board in the beginning.
Yes,
All such decisions may go to that board. All such decisions may go to the board.
five members board, but one board.
Two members of this board is not, are not agreeing.
This is what they are doing in, this is what they are doing in Netherlands.
So it might be.
In Netherlands, they have made a broad board. Every case of withdrawal of treatment goes to that board for review.
If this kind of
No,
a system will go out,
It's fine. No.
by the time the board will take a final call, the man is over.
We can fix the time limit.
Man is over.
Well, we may fix the time limit, but the doctor has to come. If he's not going to come, what is, going to be contempt? We don't know.
No.
Suppose there's no time limit, what do you do?
That will be the patient's heading.
And you,
Patient will take it.
but the point is, if we have to sort of
My
balance.
lord, brothers may not be, we may not be, there might not be unanimity in these matters, so that we can't be.
No, but my only submission is, if you want a primary, two options are, we are agreed that there's a primary board. We're also agreed that the primary board consists of treating physician plus 3 experts. That's closed. Now, question is, have a review board. Now, one option is to have a review board from doctors of another hospital consisting of, let's say, 3 people. Or you can give opinion for one leading doctor from that, or another specialist from that doctor to confirm. Need not be another team of 3 doctors. The decision taken by one team of 4 doctors is presented to another doctor of the same specialty for an opinion. Now we're looking at a person who has got cancer. Now I'm not able to visualize how many doctors you require to say that this man is going to die in 3 months. If 4 doctors says that this man has got 4th stage cancer spread all over his body, just a visualizing situation. Now,
No,
do we require
every situation may not be of
I'm giving example.
this nature.
No, I'm just giving example. So we are still having a review board. Now, if the review board is going to consist of 4 more people, it is going to become more cumbersome.
Yes,
If you want to
correct.
have it that way, it is that way.
You never
Otherwise, we
know
just have-
whether somebody has gone into coma in stroke.
Ah.
You never know whether it will come back in 7 days.
That's gone. No,
may
that is
not.
gone. That permanent vegetative is deleted. That coma thing is deleted. That's permanent vegetative is gone. Only terminally ill. There's no coma.
In these kind of matters, without review board, I don't think nobody can take.
So have a review board, with doctors from another hospital. That's all. 3 doctors from another hospital.
From another hospital.
That's all.
Now what is the position? Now the collector.
Now the collector has to constitute a board.
CMO.
The DMO, then 2 more doctors, then they will go, then that will be given to the judicial magistrate. Then he will agree whether that third member team is correct or not.
The only thing,
You
Mr.
see,
Thapar,
one thing is there, you will have a CMO all over India. In every government hospitals, one thing is common, whether it is in Assam, my brother's state, or whether it is Bombay, or whether it's
But
Chennai.
my request
You will
is,
have a CMO.
my request is please
So
do
that is why, and why perhaps this court thought was, you will have a counter check from an official missionary. That is what this court had in
But
mind.
then again, they're all
What
lacking
is
trust.
we want to
You're
know?
lacking trust in the doctors. That's what that's what they feel. You're not trusting us.
That's right, it's not a question of just.
No, no, you have to respect
You
a
have
particular
to-
medical profession also.
That's right.
Why should the collector
Now
come into
what-
the picture?
Now what is the position? Chief medical officer and two others.
Where,
Yes,
If they,
that's the
if
second.
the review
Yes.
team,
yes,
Then
what is contemplated, let us see,
Yeah.
collector must beforehand.
Yes, Your Lordship, the chief medical officer the collector will constitute a board that comprises the chief medical officer and 3 other experts.
Yeah, right.
And they will provide an opinion, and then after that, the JF, the judicial magistrate has to come to hospital and decide whether or not treatment can be withdrawn. Now, that,
No, that the JFM, after supposing the original board is endorsed by the review board,
even then,
then perhaps we can say that we can go on. There is no question of, again,
that's enough.
that should be
But
enough.
now the hurdle is what is the review board? Manoj? Hurdle
That's
is the
what-
review board. Now, whether the review board should be done by the collector or should be done by the hospital can say, all right, X hospital may say, please get three doctors. Hospital says we'll request 3 doctors from the neighboring hospital nearby to come and confirm our view. There's a review board, their decision is recorded, it's in writing. That's all.
So in the sort of, length and breadth of the country with all the, variations that you find. Them everywhere. Whereas if you say that it's a private hospital, they may not have the experts which you're talking. We started that with, that is the starting point.
We take a last round, let's say forget Madras, Bombay,
We
take
can put a
Coimbatore.
time, we can put a time.
No, take Coimbatore, Madras, chief medical officer, he has to constitute a board. And how does he have a,
What do you mean by chief medical officer, first of all? What do you mean by, it's a government
Or-
hospital?
or one thing is there.
Ah.
Every government hospital will have a team of 3 doctors consisting of CMO plus 2 persons who will certify the decision of the private hospital, that's all. That can be a review board.
Personally, I have no problem with it, but it should be, what is the stand of the government of India? Because they are the persons who would be. Everyone is not there.
But can we then discuss the review board tomorrow? We'll discuss that amongst ourselves and come back.
You don't want us to dictate today.
No, but it will not be 5, 10. At least review board will sort out some issue.
We thought we could have closed it anyway if you don't want it to.
No, I don't,
The arbitration case tomorrow, we thought that it should end today. What do you say about the review medical board? What-
Yes, the review board,
Or you want to get back to us tomorrow?
I'll get back
And then
tomorrow. I'll
let's-
get back tomorrow for 10
close it
minutes.
tomorrow.
Yes, I'll get.
So we'll also have a better,
Who will constitute the board by CMO,
Yes,
collector?
DMO is
have a better.
DMO.
DMO is better because he's in the field. Collector is an executive who will be having a lot of us.
CMO or any person authorized by him.
That's right. That can.
Because you have an additional chief medical officer.
That's right.
Centralized.
The
Like 2 boards.
collector will be having a lot of other
So the
responsibilities.
collector is constituting a board,
Yeah.
a new board. Then what the CMO will do?
Yeah, that's nothing.
Board is constituted by somebody else. Then you need a person of government officials. The review board is by the collector himself,
Yes.
by the DM, or the collector you call it. Then why is CMO required?
no,
That's not
the
required.
collector forms a board consisting of the CM.
That's why I think the collector is forming the board. Then CMO has no role because he doesn't know anything.
No, CMO will be the review head.
That's correct. He know otherwise nothing.
He'll not.
Is any reason given in the judgment made as to why this
Who is the CMO?
review board
CMOs are paid.
medical officer
no,
Any,
Your Lordship.
I don't think there is a much deliberation on.
without any specialist qualifications. If he completes particular years of subject by promotion, he is made the chief medical officer.
That's all.
So his knowledge,
His medical knowledge is nil.
He may not have.
he may not have any specialized knowledge.
Not medical knowledge, no medical knowledge. He
No, he have. He may not be an oncologist. He may not be.
He's an MBBS.
He
He's an
will,
MBBS.
No, I was thinking, Your Lordship is retiring for the day.
this according to
One
seniority.
sec, the review board can be consisting of 3 experts.
Practical reality, somebody who has passed MBBS.
Exactly.
We,
Then why
would have
we give
agreed with-
experience?
If we were hearing originally, we would have heard, we agreed with you, but
No,
what
no,
can
no.
we do?
But the point is,
There's a point beyond which you can't.
no, but the point is, we are not into review reviews. We're just trying to make the directions workable.
That's right.
That's the, Your Lordship knows Lordship can always recall the judgment.
But Rajan, you also take it. The collector is constituting a review board. with experts of a nearby hospital or somewhere else.
Yes.
And subject to your
Yes.
instruction, so CMO is not going to work.
Yes.
Because CMO, by that time, most of the time, he is not at the place where he's supposed to. be.
Correct. No, first of
But
all,
there's also one more idea. I've got.
first of all, this responsibility should not be given to the collector at all. He's an executive person, he'll be having a lot of other works, not to constitute his
He
board
is
and all those.
constituting the
Yeah.
board. He
So
constitutes.
that can be given to district medical officer,
No,
who will be more conversant with this, the ailment and all
I
that.
I've
Will be
got
able
one
to
more
take it.
suggestion. It's a review board. Now, if it's a review board, now if one team has taken and filed a report, I don't know if the review board should personally come and inspect the patient. If the records can be sent to the review board and the records show that this person is terminally, ill, that should be enough.
Would decide that.
That, them decide, we can't take.
No, that's not.
Only we elaborated the procedure, I mean, that, we are not going to change that. So, I mean, it obviously is drawn from another hospital. The members will be drawn from another. Need
No,
not
I'm
be from the
saying
government.
the question of the review board revisiting the hospital, I'm just putting, please think about it.
Revisiting.
No, he says that entire team must come back to the hospital, check the patient again, then file a report, then that should
They
go to
they
judicial.
will necessarily have to do that. What,
No,
how will they know?
I'm just suggesting
Yeah.
that
No,
suppose
we can't.
there is a report by X hospital that Mr. X has got advanced cancer. These are his X-ray, these are his medical report, this is his MRI, whatever it is. If that is sent to the review board
No, no,
and the review board can see the document and say, yes,
no, no.
it is a case, that's enough.
This is not, this is not a.
It should not be, because they will tell you.
He has to come
Very, very
back.
clearly it is stated, who will,
That's
they
all.
shall jointly visit the hospital.
I'm
where
saying that's not
the
necessary.
And if they concur with the initial decision of the medical board of the hospital, they may endorse the certificate. This is a procedure which has
Correct.
been laid out with, after reserving the matter with great care, they have laid it out.
Yes.
We are wanting in one moment.
Yeah,
we are
leave
trying
your
to talk
Can't do
about
it. Not criminal appeal there.
Only point is, the medical officer, instead of the collector, we can knock out the collector there.
Yeah.
The chief medical officer, upon being notified,
Correct.
he will constitute a mode.
Yeah.
This is what we can bring.
Yeah.
And what is the remaining portion? Anything else is there? 198.5.1, please, you have. You are trying to change, a case of refusal which is to be challenged in a restitution, you want it to be referred to a medical board. Just see 198 point, at page, is only what last remaining.
No, we have not deleted the High Court.
Close.
No, but what happened was, we did not delete the High Court part of it since the Lordship said you're not sitting in.
Then
review.
again, red is coming again.
Yes,
No, what is this last red?
no, now
There are several. brother.
there's some more reds there.
There are several, not just last.
So are you flushing out the other reds?
We'll show it to Lordship. It'll take half an hour to say what it is.
So we'll also go through it. Today,
That's
you're
what I'm
giving it. So we might get a better idea. Then come tomorrow, what else can we do?
Brother, one last word. if I may. Actually, Mr. Dalton had mentioned about Justice D.A. Desai saying God is above us.
Only God is above.
Only God is above. Brother Ravi Kumar talked about the orphan. And Justice Joseph talked about the unmarried orphan. So then you have close relatives and responsible person, and then third slash Ram Bharose.
My understanding.
Yes, thank you, Lordship's time. Your Lordship is really taking so much of.
Eh?
Thank you, Lordship's time.
The
Lord.
passage
Almost
of
work.
time, the distrust has so developed, we are not trusting the system going on.
That is the main anguish of the doctors. Lord.
We have to trust them.
The main anguish of the doctors is this kind of multiple thing again and again and again, as if they're just going to pull the plug for anybody.
There is one principle of logic. One principle of logic which we are actually missing out. You see, if they want if the doctor certified that the treatment should be cut off, actually it's not in their financial interest.
Yes.
That's right.
So ordinarily, when they certify that he has reached that stage, please cut it off.
Yes.
It'll go against the hospital because the hospital will stop earning money. Still, when the board say, yes, he says that it's condition, please cut it off. That normally the inference ground should be under 114, That's when they're acting bona fide.
Yeah.
They would not do it normally.
Presumption, now, 114 presumption.
You are, in our profession, the best relief is the remand, it seems.
Huh?
That's what it is said.
Huh?
The best relief party gets is, so far as law is concerned, it's the remand order. That's what it is said.
So you go back.
Tomorrow.
Tomorrow when? Tomorrow when?
Tomorrow when? So can we do one thing? Let us complete the arbitration matter in the forenoon session. We'll keep this at 2 o'clock. So that
Keep this at 2 o'clock.
after the arbitration,
Keep this at 2
you
o'clock.
can come at 2. You're free to come with arbitration also. That's a different matter.
No, no.
Yes.